Testing 1 2 3. Testing 1 2 3. This is a test of the Seventh Circuit Court of Appeals. Testing 1 2 3. Testing 1 2 3. Testing 1 2 3. Testing 1 2 3. This is a test of the Seventh Circuit Court of Appeals. Testing 1 2 3.
Good morning, everyone. We will start with the first case, United States versus Bruce Lee, appeal number 221293, 222138 for appellant. Mr. Shannon, please proceed.
May it please the court, counsel. My name is Nishay Sanin. I represent the appellant, cross appellee, Mr. Bruce Lee, in this matter before the court, and I'd ask to reserve 5 minutes for rebuttal. Your Honors, this case starts with issues at the indictment level, goes through the trial level, gets to sentencing, and then there's the issue of what happens after the sentence is imposed and the forfeiture issues raised by the government. So unless Your Honors have specific questions as to all the issues raised, I can address them unless Your Honors have specific questions as to either the indictment, the Rule 29 motion, the sentencing guideline calculations, or the forfeiture. Because there's so much, I just wanted to see first if Your Honors had any questions as to specific categories.
With regard to the motion to dismiss the indictment, so it seems like the issue is really how one defines the scheme, right? How broadly one defines the scheme.
Well, I think the issue becomes, Judge, is how broadly is a scheme defined, and then what becomes the wire in furtherance of that scheme. The situation in this case, as at least as the motion to dismiss indicated, is that it's duplicitous, number one, as there's two different schemes alleged in each count.
But why do we have to look at it that way? It seems to me the government's position is that there's an overarching scheme to profit by getting these tickets from the White Sox at very, obviously the tickets were designed to be promotional sorts of things, and to make the money from it. So both the acquisition of the tickets and the sale are integral parts of the scheme.
They are not, Your Honor, because there's one victim, the White Sox, in the first scheme. What happens in this so-called second scheme, which Your Honor called the profit or the sales from StubHub, do not affect the victim whatsoever.
See, I don't see it that way. At least what I understand, especially looking at some of our earlier cases, is that the White Sox actually have a business reason to either give complimentary tickets because of late season attendance. It's a form of advertising, basically. And what this second part of the scheme is taking from them is the goodwill and the opportunity to bring fans into the stadium at low to non-existent prices and instead change things.
Well, Judge, respectfully, if you look at what the White Sox benefit from, they received the compensation that they had requested. Let's say we use one of the vouchers for $5, the $5 voucher. They received those monies.
Well, they received the money, but I'm talking about the goodwill of the fan, the customer. If you give me a ticket and I can go to the White Sox for $5, let's say, I'm feeling all happy. I bring my family members along. So it's more than just the dollars. And if you look at our decision in the Mount case, there's an interesting discussion about why a sports team might want to sell tickets at below market clearing prices.
Correct, Judge. And if you look at Mount and you apply it here, yes, they're selling at a low discount rate. However, at some point, that scheme related to the White Sox ends. And that ends when Mr. Lee provides Mr. O'Neill or Mr. Costello, the co-defendants in this case, the money to purchase the tickets at that discounted rate. So the White Sox got what they were asking for, which is...
Maybe we just see it a little bit differently, but I understand that that's your point.
And then, Judge, if you look at...
Why don't we view the scheme from the standpoint of the defendant, Mr. Lee? I mean, after all, as Judge Wood noted, he wasn't getting these tickets just to see if he could. He was getting them to profit from him. And so why can't we, from his perspective, look at it and say, well, the scheme is getting these tickets in the way they did from the White Sox and then selling them in a manner to profit from it. Otherwise, what's the point of the whole thing?
Because, Judge, the scheme ends when he gets the tickets from the White Sox. What the government alleges, at least the way they allege it in the indictment, is a second so-called scheme. That is to sell these tickets for a profit. But if we look at who the victim supposedly is in the indictment and the way it's alleged, it's the White Sox.
If there's two schemes, what's the purpose of the first scheme?
The way it's alleged is the first scheme is to get tickets at a discounted price, which ends at the time he pays and gets the tickets.
So the purpose is to be a ticket collector.
Is to get the tickets.
Okay.
The second scheme, or a so-called alleged scheme, which does not affect what happens in the first scheme, because there's no allegations that he needed the money from the profits of the sales from StubHub to go back and then buy more tickets. In fact, the evidence at trial showed that there was sufficient money always in his account to buy the tickets without having to worry about the sales as what we call the second part of the scheme.
So the only purpose of the first scheme was to get discounted tickets from the White Sox.
Correct. And then the victim is done, even though if you call it a victim, they got paid what they were asking for, either the $5 voucher, the $15 rain delay, whatever voucher was used.
But vouchers were not always used for
Well,
the first portion of that scheme, correct?
Well, in the first portion, there was vouchers. Then the second portion is when the
No,
co-defendants...
the first, I'm talking about actually acquiring the tickets.
There was, in certain circumstances, there were actual physical vouchers.
In certain circumstances, there were no vouchers.
Right. When the co-defendants told them we don't need the vouchers anymore, they just entered in the code number to get it for that voucher, which is obviously the materiality issue, whether or not the White Sox cared about whether there was vouchers because they were just thrown in the garbage.
Why isn't the fact that as soon as they were alerted to this scheme, they immediately notified law enforcement? Why isn't that pretty good evidence that they did care about it? Maybe they were sloppy, maybe they had bad, tracing procedures. Not everybody is perfect, but as soon as they do find out, they pursue it.
Well, but that scheme's already done, Your Honor, and that's the issue, whether or not there's two schemes or one scheme. The scheme is done.
Well, they shut it down, though, right? They find out.
Well, actually, that's not true, because if you look at counts 12 and 13, they let those sales continue to happen, so they don't shut it down. And that's one of the issues we raised as to counts 12 and 13, which happened after the fact that law enforcement already notified. So they just don't shut it down. The White Sox got paid what they were asking for if they are a victim, per se, as to a scheme to defraud with wire fraud. It's because the vouchers weren't provided to get that price tag. However, then there's a gap, and then there's Mr. Lee selling the tickets for a profit to him. The White Sox are not a victim because he profited because they already got the money that they were asking for. It's a property or money crime for the purposes of the wire fraud, which then goes to the next issue of whether or not...
Did they receive any money for those vouchers? I guess the second portion, what you described as kind of the second portion, when the employees of the White Sox indicated they no longer needed physical vouchers. Were the White Sox receiving any financial benefit from those codes and like for those special games and things of that nature?
There was money being paid by Mr. Lee for the cost of the voucher ticket and money to the individual who was then giving him the tickets, either Mr. O'Neill or the other co-defendant. So the White Sox were getting their money based on whatever voucher code was used. That was being put in the till because it had to be, because that's what code is being used. So I'll give you an example, Judge Pratt. If it was a $5 voucher, that $5 that would end up on the ticket when they entered it to print, that $5 had to end up in the White Sox till, because that is a computer-generated, tick for tat. The money that was paid for the tickets to the co-defendants, they pocketed, and then at that point, that is done. There's nothing left to happen. Now, also, evidence...
And can I just go back to the other point I was making, though? Yes, it's done in a way. The $5 is in there. But what the White Sox had been trying to do with that $5 ticket was put a happy fan in the stands who had paid $5. And instead, when that ticket goes out on StubHub, I don't know, if it's a good game, maybe it goes for $100. It goes for some amount of money, not $5, which is why it was a profitable
But Judge,
scheme.
I'm sorry. I didn't mean to interrupt you.
No, go ahead.
I can go buy a ticket with that same voucher for $5 and go put it on StubHub. The White Sox are trying to get people into the stadium, so they're discounting the prices. They want those discounted people because they know other monies are going to be spent on beer and all that stuff. So they want people in the stadium. I myself can go buy that $5 ticket and then go sell it on StubHub for $100. There's nothing stopping me from doing that just because I used a voucher ticket.
Well, this though is an overall, they go to quite a bit of trouble. And actually there are these recordings even of Mr. Lee saying, I know this is, not right. It was a business to, frankly, to scalp in a way that was not consistent with what the White Sox were doing.
Well,
I don't want to use all your time, by the way. Can I change the
Yeah, of course,
subject
Judge.
and
Judge,
go
it's your
over
courtroom.
to the forfeiture business?
Okay.
So here's what's holding me up on that. It appears to me that the district judge in the sentencing proceedings first of all, has a full discussion of forfeiture to the point where he actually accepts Mr. Lee's amount for the forfeiture. So Mr. Lee is on notice that forfeiture is on the table. He has a full opportunity to present his views on that. The judge is persuaded by his views and uses that number. And then, as I understand this record, the judge orally pronounces sentence, and that oral sentence includes the forfeiture. So in those circumstances, why isn't just the general rule that you can always conform the written sentence to the oral pronouncement and that the oral pronouncement controls the one that we should be following? It's essentially the Rule 36 approach.
Because, Judge, the rules for forfeiture were never followed by the government. They never filed a preliminary order of
I
forfeiture.
know they didn't, but I'm saying it depends on what kind of rule you think this is, because the purpose of this rule surely is notice and opportunity for the defendant to contest the amount of forfeiture, an opportunity that Mr. Lee took full advantage of. Why can't this one mistake by the district court be corrected?
Well, it's not a mistake by the district court, Judge. It's a mistake by the government, because the government is the one who needs to file the preliminary order of forfeiture. In our situation, they don't file it till 4 months after the sentence when the notice of appeal has been filed. So this is their fault. They don't file it. Then they try to chalk it up to a clerical mistake, but you can't have a clerical mistake when nothing was filed in the first place.
Well, the reason I think they're saying it's a clerical mistake, which may be wrong, you may be right, had the oral sentence not been pronounced as it was, I think you would be on very solid ground. But the fact that the judge orally does pronounce a sentence that includes forfeiture, I think has some significance here.
But, Judge, if you look at the case law even out of this district and others, it follows the four-part test. That preliminary forfeiture has to be filed by the government in order, even if there's an oral discussion about it, and it doesn't end up in the sentencing or as what happened in this case. There's still a procedure under the rules 32.2 where it has to be followed, where A, there has to be notice in the indictment, which there was. No one's contesting that part. There was no preliminary order that at some point prior to the sentence, the judge enters the preliminary order. That just didn't even happen in this case. There's discussion about it without a preliminary order being entered, and then in the sentencing, it's void.
What about this language in the Sixth Circuit's Maddox case, where it says the district court did not, for example, enter a preliminary forfeiture order before either Maddox's or Carmen's sentencing hearings, blah, 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 and then it says, such failures standing alone might be remedied where forfeiture is ordered at least during sentencing, because that necessarily ensures that the defendant knows of the forfeiture at sentencing. So at least the Maddox case seems to suggest that this is a correctable flaw.
But, Judge, in that case, it's discussed. There's a preliminary order of forfeiture. It's discussed, but that even in our case here, it's not in the judgment. The forfeiture is not in the judgment.
It's in the oral judgment.
There's an oral pronunciation of sentence, but the sentence becomes final when the judgment is entered. Just like a notice of appeal can't be filed until the written judgment is entered. That's the guiding factor.
Well, actually, they are filed, and then they spring forward sometimes.
But the stamp date would be, Judge, when the notice or when the physical written judgment is entered. And that's the basis for where there's the problem here. So it can't be a clerical issue because it was never in the judgment.
But why is this argument not waived?
By who, us or the government?
Yeah, by you.
This is the government's argument.
I'm saying, my question being though, if, as Judge Wood is suggesting, this was fully argued forfeiture in the trial court, and at sentencing, the defendant actually put forth a number, did not contest forfeiture, agreed that forfeiture was appropriate, however, argued for a different forfeiture amount. The judge agreed with that calculation based on the evidence presented at the trial and orally pronounced that sentence. Does this not, and we're looking at the Shakur case, which is the case that the district the district court relied on, why could this error of not entering a preliminary order of forfeiture not be corrected under Rule 36?
Well, Judge, there's two different issues because there's no preliminary order of forfeiture, and then the judgment, actual physical judgment, written, not oral, did not contain it. So you have multiple errors that are not clerical in nature, and therefore cannot be fixed. And then the government waives the amount of time to fix a clerical error. They wait 4 months after a notice of appeal by Mr. Lee is already filed before they get there. I see I have 23 seconds left for rebuttal, so if your honors wouldn't mind, I'd like to save at least 20 of those.
Mr. Sandin, I'll give you 3 minutes for rebuttal.
Thank you, Judge.
Thank you. All right, let's hear from the government. Ms. Peterson.
Good morning. May it please the court, Michelle Peterson for the United States, and I'm going to start with the government's cross appeal.
Can I ask you a question about the government's cross appeal
Yes.
first? Judge Cannelli, when he denied the government's request to amend the judgment,
Yes.
didn't think that he had entered an order of forfeiture, right? And so I suppose we could read the sentencing transcript and think to ourselves that he did, but he himself stated when he announced his ruling that he hadn't. Why doesn't that just answer the question of whether or not Judge Cannelli did or did not enter orally a preliminary order of forfeiture at sentencing when he himself didn't think that he did?
I think that Judge Cannelli's reasoning is a little more nuanced. And I think that what Judge Cannelli was concerned about when he was dealing with the government's motion to correct the clerical error was whether or not he had entered a preliminary order of forfeiture, not whether or not he had entered forfeiture at all. And he was trying to look at Rule 32.2 and square what had happened with the rule. And I think Judge Cannelli was concerned that without a preliminary order of forfeiture, he may have not had the authority to order forfeiture at sentencing. And Judge Cannelli acknowledged that it was murky and unclear. And it was a little bit sort of confusing about what to do in the procedural posture that he found himself in.
But his confusion, I think, comes from the language of the rule, right? It says the rule 32.2b for capital B states the court must also include the forfeiture order, right? Not just forfeiture statement, forfeiture order, directly or by reference in judgment, but the court's failure to do so may be corrected at any time under Rule 36. It seems to me that's what he was focusing on, right? Is how to make sense of the word order as it meets that rule. And so it seems to me that his kind of inquiry was on point. And then he concludes, you know what, I didn't do that. And then so I'm still trying to figure out whether you're asking us to second guess Judge Cannelli and say, in fact, even though he didn't think he had entered an order of forfeiture, that in fact he had.
And I think that Judge Cannelli was...
Well, if you could answer my last question
Yes.
first, which is, are you asking this court to second guess Judge Cannelli and say, in fact, Judge Cannelli, you had entered a forfeiture order during the sentencing, even though you didn't think you did?
Yes, I suppose we are asking this court to do that. And I think some of the confusion comes with Rule 32.2b(4)b, which is what Your Honor was just referencing, that the court must include the forfeiture when orally announcing the sentence, and then must include the forfeiture order in the judgment. Does that mean the preliminary order, or does that just mean a forfeiture order generally? And I believe that that means a forfeiture order generally. Rule 32.2, as it talks about orders, sometimes it talks about preliminary orders of forfeiture, sometimes it talks about just orders of forfeiture, indicating that there's a difference between the two. And there are circumstances envisioned by Rule 32.2 where there would not be a preliminary order of forfeiture at all. Cases where the court can't determine the amount of forfeiture. And in that case, Rule 32.2 states that there could be a general order instead. So there are different vehicles that a court can use to arrive at ordering forfeiture at sentencing. I don't think certainly the absence of a preliminary order does not mean that there can't be an order of forfeiture at sentencing. And I think that that's where the district court was getting hung up on whether or not that could happen.
But don't you think then that if we read 4b that broadly, then we're basically reading out the word order? Because it could just as well read, the court must include the forfeiture when orally announcing sentence, or must otherwise ensure that the defendant knows of the forfeiture sentencing. The court must also include the forfeiture directly or by reference in the judgment. I think if the rule had said that, then I think your argument becomes more persuasive. But unfortunately, the rule doesn't.
The rule doesn't, but there was an oral order of forfeiture, and both parties have cited cases where at sentencing something happens where the court says something like, oh, we'll get to forfeiture later, or I'm going to include forfeiture in the judgment without saying specifically what's being forfeited or what amounts. In that case, that wouldn't be enough. But in this case, the judge was clear at sentencing. He said, the forfeiture amount will be X, and then he stated a specific amount. So he did make an oral finding as to the amount of forfeiture, and that certainly can be an order of forfeiture.
But
under this rule.
normal forfeiture orders, but the usual thing you'll see with a preliminary order, I'm sure you know this, is you'll not only see a certain amount, but you might see, this car and this gun or this item is among the things that the government's going to take. And so the defendant has an opportunity to say, wait a minute, that's not even my car, or whatever they want to say about that. I take it the forfeiture here, you're just assuming, is just dollars.
Correct.
From wherever he can put his hand on the money. But there are purposes to the preliminary forfeiture order that when you slide over all of these things, maybe have not been achieved here. And it really seems sloppy of the government, by the way, not to have made sure that order was in there.
Yes, I recognize the government failed in not providing a draft preliminary order or general order before the sentencing so it can be ordered. But I do think in this case, it is a money judgment. Then the point of a preliminary order of forfeiture is to provide notice. And when we're talking about specific property, a house or a car, that's heightened because the parties want to make sure no one else has a claim to that. The parties want to make sure the PIN number or the VIN number is correct. There are certainly reasons why a preliminary order of forfeiture is important. But in this case, it is money, and it's money that was not decided until sentencing. And that's what both parties had sort of agreed. The court should hold a hearing, and the court should discuss and decide how much money should be in the money judgment. So the lack of notice, the lack of a preliminary order of forfeiture did not impact this particular defendant because he knew how much the government was seeking. He knew it was an issue at his sentencing. He had a full opportunity to be heard, both written and orally. And he had a hearing where the judge found in his favor and found, yes, I find forfeiture in the lower amount you're seeking instead of the higher amount that the government's seeking. So if there had been a general order or preliminary order of forfeiture, it wouldn't have provided any additional notice to the defendant other than what he was already getting in the process that he already received.
Even if you're right, is this something we can do? What I'm looking at is the classifications that the Supreme Court used in the Dolan decision, whether something was a jurisdictional structure or whether it's a claims processing set of deadlines or whether it's just a more, this is the way you ought to do it, time-related deadlines, but that are maybe subject to this kind of functional adjustment that you're talking about. I'm not interested in calling it jurisdictional because the way I read the Supreme Court of late is they're trying to wean people from that categorization, but I'm not sure why it's not a claims processing deadline.
Well, of the circuits that have analyzed it, 3 have found that it's a time-based directive, and 1 has found that it's a claim processing rule. But either way, in this case, the court can provide the government the relief that it seeks. Because claims, if it were a claim processing rule, the defendant has to assert an argument that the time deadlines had not been followed prior to a ruling on the merits. And if a defendant doesn't, then that claim is forfeited. And not forfeited in the way that we talk about forfeiture and waiver, but forfeited in the sense of he cannot now try to get the court to enforce that deadline. And in this case, at sentencing, the defendant does not object. He does not say there was no preliminary order of forfeiture, there was no general order of forfeiture. It proceeds to an argument on the merits, and the court decides it on the merits. And once that has happened, the defendant can't then assert that there had been a timeliness problem. That's the Eberhardt case and other cases. And in this case, the defendant waited until months after the sentencing to raise for the first time there had not been a preliminary order of forfeiture, and it's too late. So even if this court were to determine that this is a claims processing rule, it could still give the government the relief it seeks. And certainly it could give the government a relief that it seeks if this were a time-based directive, as the government articulated in its brief.
Staying on the topic of jurisdiction versus other types of rules, I'd like to talk about 4C, the time to appeal.
Yes.
All right. So 4C says the time for the defendant or the government to file an appeal from forfeiture order or from the court's failure to enter an order begins to run when judgment is entered. The government here failed to file an appeal of the court's failure to enter a forfeiture order. So why doesn't that end the inquiry right there?
Well, the government's position is that the oral pronunciation of forfeiture at sentencing was a forfeiture order, and the case law is clear that a judgment must match what happens orally at sentencing, and if it doesn't, that failure can be corrected at any time. And so the government was not untimely in seeking a Rule 36 motion, and it was not untimely because that could have happened at any time.
Well, then, if the government thought that the court had entered a forfeiture order, then why did it ask the court to amend the judgment at all?
With the motion for a preliminary order of forfeiture, Your Honor, I think that was the government's sort of clumsy way of trying to bring it to the court's attention, trying to get that order put into the judgment. And so I think it was just an artful attempt to get the relief that it sought.
Are there any other consequences? I mean, having it all nice and tied up in the written judgment, are there enforcement advantages or other things that, as a practical matter, would change?
I don't think that it is enforceable until there's a written order in the judgment, until there's a final order of forfeiture.
So that's why we have these motions, to conform the written judgment to what was pronounced orally.
Correct. Correct. So I don't think the government's appeal is untimely, and that's because there was an oral order of forfeiture. All right, with 2 minutes left, unless there's any more questions about forfeiture, I will move sort of back to where Mr. Sannon started, which is the scheme to defraud. You know, in here, a properly instructed jury convicted the defendant of wire fraud, and this court should affirm that verdict. The scheme to defraud, as alleged in the indictment and proved at trial, had 2 pieces, or had multiple steps. The defendant and his co-schemers got over 30,000 tickets from the White Sox. They did it through materially false representations, the vouchers, or the thousands of rainout tickets they got for free with no money being paid to the White Sox whatsoever. And defendant...
Ms. Peterson,
Yes.
I'm sorry, we have limited time. Can we move to the sentencing question regarding the sentencing calculation
Absolutely.
around loss?
Yes. Yes, the district court did not clearly err when it used gain as the loss figure for guidelines purposes, when the actual loss could not be determined. There was a lengthy sentencing hearing, and during it, the district court and the parties sort of went around and around about this idea of what would have happened but for the defendant's fraud. All these 30,000 tickets he obtained, would the White Sox have sold them? Would they have not sold them? And how much would they have sold them for? And in the end, the district court concluded that it was in a realm of uncertainty, and that he didn't think there was any way to tell what of those tickets would have been sold. And because he couldn't tell which would have been sold or not sold, he couldn't calculate an actual loss. And without an actual loss, he properly turned to the guidelines and saw under 2B1.1 application note 3B that he could use gain as an alternative measure of loss because he could not reasonably determine the full amount of actual loss. The district court determined that for some of the tickets he could determine some amount of loss, but not for all the tickets and not for the over 20,000 tickets the defendant got completely for free. And that's
What's the distinction between this and the Mount case using I think it was the bargain element methodology?
So in the Mount case, the tickets at issue had been taken. No money had been returned to the twins whatsoever. And this court, in determining what that loss would be, thought the loss was not only the amount of the face of what the tickets that they were going to sell to the customers were, which was $12,000, but this court also said there would be a loss of the difference between that amount and what the defendant in that case was willing to pay for it, what the market value kind of on the street would have been. Because there's the difference between that face value and the market price was an element of value to the twins. So applying Mount to this case, the loss is not just the face amount on the tickets. It's that plus the whatever amount those tickets could have sold for had the White Sox been able to sell them legitimately on the open market. So I do think Mount supports, a higher loss amount in this case. In the end, the district court did not use Mount. It used Gain because the district court could not determine which tickets would or wouldn't have been sold. And I think that was not clearly erroneous for the district court to do so. All right. Seeing that I'm out of time, this government respectfully requests the court affirm the defendant's sentence with a limited remand to enter a final order of forfeiture and to amend the judgment.
Thank you, Ms. Peterson. Mr. Sasson, you have 3 minutes, please.
Addressing Justice Pryor's question about the Mount case, the Mount case should have been followed in this case because the value of the tickets could have been determined to that $74,000 some odd dollar amount that then was used for restitution purposes. So Mount is used for and I'm not saying restitution and loss are the exact same thing, but under Mount, Judge Kennelly used Mount to determine what restitution was, which is based on actual loss or what the White Sox are out and should be paid back for restitution purposes. So therefore, that amount should have been used as actual loss as the price of the tickets or loss to the White Sox. And in fact, during the sentencing hearing, we did go back and forth, and there was arguments as to what the ticket amounts were. For the judge to use Gain, which if you look at the guidelines clearly says as an alternative measure, here there's no basis for an alternative measure because this court's case in Mount guides Judge Kennelly on how to determine what the actual loss was, which is the $74,000, which would have significantly reduced Mr. Lee's guideline range. Turning over to the forfeiture issue, Justice Lee, as Your Honor said, in this situation, the government has forfeited its opportunity to go back and ask for forfeiture. They didn't follow the required steps. Then they filed a motion. Judge denied it because he said he never ordered the enter. In the actual final written judgment, as the government concedes, there is no order of forfeiture, so how can Mr. Lee then have to file something saying the deadline is blown? The government had their timeline to get the final written judgment fixed. They did not do that. They waited some 4 months after the notice of appeal by Mr. Lee was filed to then go back and what they now call fix a clumsy situation.
So that's why this, in some ways, boils down to the question whether this is a Rule 35 situation or whether it's a Rule 36 situation, because there wouldn't have been a deadline if it's Rule 36. There definitely would have been a deadline if it's Rule 35.
Correct, but
and if there was a mistake in the oral order, I mean, it's really procedural steps that you're arguing are mistaken, not the substance of the oral judgment.
Well, it technically is the substance because Justice Wood, there has to be a preliminary.
I'm just a judge. Don't worry.
Judge Wood, sorry. There has to be that preliminary order of forfeiture before you get to sentencing. And as Your Honor described earlier when you used the case of cars and things like that to put the defendant on notice, and forfeiture has always been a preliminary order before you get to sentencing. The judge enters the preliminary order before you get to sentencing. You argue it if there's arguments to be made at sentencing. The judge orders orally or makes an oral ruling as to what forfeiture would be and then includes it in the final judgment. Here you're missing several steps, which you can call procedure in that situation because, one, there's never, prior to sentencing, a written preliminary order of forfeiture filed by the government. The judge never rules on it before we get to sentencing. We get to sentencing, there's oral arguments and discussions regarding it. Then you get to the final written judgment, which, as I've stated when I was up here before, is what triggers timing and clocks to start, even though Your Honor said, yeah, it backdates in the system, or backstamps. But you have multiple steps that the government failed to come forward with, and therefore they forfeited. Then they don't come back in 14 days. They finally realize after the notice of appeal is filed by Mr. Lee, that there no longer is a forfeiture that they can collect on. So the government's right. They cannot collect this forfeiture because there was never a forfeiture entered as we sit here today. My time is up unless your honors have any questions.
Thank you very much. All right, the case will be taken under advisement. Case number 2 today is Michael Schreffler versus City of Kankakee. We'll hear from the appellant. Mr. Herbert.
Yes.
Good morning, sir.
Good morning, Your Honors. May it please the court, counsel. My name is Dan Herbert, and I represent Michael Schreffler in this case. Respectfully, I would ask for a 5-minute rebuttal in this case. To begin, I want to give a very short resuscitation of the facts and the timing. And obviously, if Your Honors have any questions about the facts, I'm certainly willing to offer. But I think it's very important in this case, the timing of some of these issues. In 2009, Mr. Schreffler was hired by the Kankakee Police Department and served with honor and distinction, and it's undisputed that everyone considered him an excellent employee. In 2016, in February 2016, Michael Schreffler made some comments on a Facebook post that were about a halftime show of the Super Bowl involving Beyonce. And the comments were in poor taste, but they were not overtly racist in any way. Anyways, the issue was brought to his chief. His chief gave him a written reprimand. Shortly after that, Michael Schreffler found out that his supervisor, then Lieutenant Hunt, had made some posts on his Facebook page, which were extremely disparaging posts racially, which showed an animus toward white people, and that's been admitted by some of the defendants here. Mr. Austin, who was a commander with the police department, characterized him as ideology of white supremacy. So
Both Dumas and Scheffler were reprimanded for their comments, and that was a different supervisor.
that's correct.
Okay.
That's correct. I'm just trying to give a little back frame here. What's important about that is then Lieutenant Hunt believed that Michael Schreffler was a person that essentially outed him about the Facebook posts, and he has made comments to other employees that he was going to find out who did this, and he was going to get that person. So what happens
Mr.
is...
Herbert, if I could ask you a couple of questions. Currently, is there some sort of arbitration proceeding that is taking place?
That's a good question, Your Honor. There is. I know that there is discussions about an arbitration. Last I heard, was probably about 6 months ago, where they were talking about settlement. And to my knowledge, and I'm sure counsel could speak to it better than me, but I know that there has not been an arbitration procedure.
So an arbitration proceeding hasn't been formally initiated? Or let's start from the end. Has there been an arbitration hearing scheduled?
To my knowledge, there has not, Your Honor. Last I heard was 6 months ago, and they were still up in the air. But to that point, and that's an important point, Your Honor, this arbitration issue is kind of a red herring in this case. The fact here is that there was a choice that was made, and the choice was made by the village to proceed via the Board and Police Commission for disciplinary hearing. They didn't choose to go through arbitration.
But as I understand it, the CBA has post-termination proceeding provisions that would allow, I don't know whether allow is the right word or mandate is the right word, but that would certainly permit an aggrieved former employee to seek arbitration through the CBA with the aid of the union. Is that correct?
There is a provision in there, and I believe that it's either a grievance or a hearing for the board.
But can I also direct your attention to page 52 of the red brief? The bottom of page 52, it's represented in this brief that since the district court's judgment was entered, I'm reading, plaintiff decided to avail himself to the grievance arbitration provided by the CBA. The parties submitted to a binding arbitration on February 22, 2023 and February 23, 2023, and are scheduled to submit closing arguments in writing to the arbitrator by May 1, 2023, just 2 weeks ago. So either you're saying that this is happening without your knowledge, or that it's mistaken, or something. I'm having trouble coordinating what you're saying with what this representation is.
Your Honor, I agree. I apologize. I'm not involved in these arbitration proceedings, and like I said, my last knowledge of the issue was that 6 months ago, and there had not been anything pending. Apparently, there was an arbitration, but if I can go back to my point, that really, it's irrelevant to the proceedings here, because not only did the village choose to they didn't offer him arbitration. It wasn't available.
No, it was his right under the CBA. I'm not sure it's irrelevant, because for purposes of federal due process concerns, it doesn't really matter which vehicle of state law or other provisions, perhaps a contract, is being used. It looks as though he's being given a full opportunity to be heard, to address whatever accusations were being made against him, to give his side of things. I mean, the normal points that you would expect in a due process proceeding.
But I would submit that this is all after the fact. It's all after he was terminated.
Well, if
it's
we
after
wanna
we
look
filed
right.
the lawsuit.
Okay, and so I actually looked at this record very carefully from the point of view I think you're now alluding to. Who told him what before the fact? You know, was he given notice of what things he may have, you know, in somebody's view done wrong? Was he given a chance to say something? And in informal ways he was. And so informal processes, pre-deprivation, followed by a full-blown formal process post-deprivation under cases like Loudermill, is acceptable.
But he wasn't provided his rights, and it's really undisputed, because Chief Hunt, Lieutenant Kidwell, Commander Austin, even Chief Dumas, they have admitted that he did not receive his due process rights.
He didn't receive certain rights and privileges that local law would have given him, or that the CBA would have given him. And I'm just trying to look at this from the point of view of federal due process, because it doesn't necessarily map right onto every detail of local law.
Well, to the federal question, he certainly has a right to be to answer specific allegations
Absolutely.
made against him. He was never provided notice of allegations. It's certainly not notice to the level.
What about when he was given the last chance agreement, and he has meetings with people at which he's told, you know, at the training session, there's word that certain things happened, and it's informal. I don't have any doubt that, you know, he's not brought before a formal looking room with a table in it and everybody's sitting down, but it seems that he is told what he's done that people are concerned about.
Well, it was much less clear than respectfully what the defendants submit this. The timing of this is he was disciplined and he was fired for allegedly posting information on a Facebook account not related to the incident in the February 2016 Super Bowl. But
I thought he was fired because of the after the investigation of what took place during the active shooter drill.
He was, Your Honor, but what we're saying is that was a made-up reason. It was pretext, and there's evidence in the record to establish this.
Is there any evidence that the commission knew about the Facebook post? I didn't see.
Well, all I can say is that there was a conversation between Dumas and the hearing commission about the charges that were never brought, and I don't know what informal discussions took place. But here, my answer to that, Your Honor, is it was very well known within this county. These Facebook posts created a lot of dissension in the police department and in the village in general. So to certainly one of the commissioners, whose name escapes me right now. He admitted that he knew about these Facebook posts because the Facebook posts were critical of the black administration within the police department, and it alleged corruption, and it alleged racial disparity in hiring and promotions. And my point is, in the plaintiff's point is, that's the reason he was fired.
So,
Despite,
Mr. Dumas was deposed.
he was.
Yes. And so presumably he was asked what sort of information he shared with the commission with regard to the circumstances that led to the termination. And as part of that deposition, was there any facts uncovered that Mr. Dumas had told the commissioners, look, one of the reasons should be the fact that there were these February 2016 Facebook posts, or 2018?
There was no admission to that point, but I would suggest that there's certainly inferences that's what it occurred. We know that when they brought the charge, which resulted in the termination, the charge included information that shouldn't have been included in the charge, namely discipline that was beyond a certain scope, so it shouldn't have been in the record.
Are you referring, for example, to the reference to the 2-day suspension of March 5, 2018?
Yes. And to your point, Your Honor, and I believe that there was information. Yes, there was information about his Mr. Schreffler's background, and that included he had previously, just a few weeks prior, been given a 5-day suspension for these 2018 Facebook posts. That information, I'm almost positive, Judge, and I can certainly find out, Your Honors, but that was included in the charging docs that went to the commission. Now,
That's what the record seems to indicate, that the charge that Dumas sends to the Board of Commissioners begins by saying this termination recommendation is based on several incidents, and then goes on to indicate what they were: the racially charged language towards the chief, threatening to kill him, name-calling, progressive disciplinary actions, several written reprimands, February 10, 2016, December 21, 2017, March 5, 2018. So the board is told by Dumas of all of these things.
yes, and thank you, Your Honor. I appreciate that. And that's an important point here. We know that at the very least, even if we believe all the allegations about the training incident where there was an alleged threat made, which I'll get to that in a point, that there's very significant questions of fact whether that even existed. But at the very least, the board considered this Facebook post from 2018 as part of the reason to terminate Mr. Schreffler. Mr. Schreffler cannot be disciplined for these posts. It's been admitted by the defendants in this case that he posted as a private citizen, and he posted about matters of public concern, namely.
I'm not sure those are full admissions, actually. I mean, that's something we would need to look at.
I would say, Your Honor, that they admitted that police officers certainly have a First Amendment right to post.
But as you well know, there's a lot of nuance in that area of the law, and you look at cases like Garcetti against Ceballos, and you see that even things that look like they're a mixture of public concern and just good office discipline, the Supreme Court has said public employers have to be able to function as normal employers and discipline people if they need to.
Agreed, Your Honor, but I think there is an admission here from the defendants in this case that the Facebook posts certainly were not a basis to terminate him, but also that they were protected activity that they couldn't discipline them for. They gave him a 5-day suspension. He appealed it. The mayor sat on the grievance commission, which was unprecedented, and they agreed to reduce that. Actually, they agreed to get rid of it for
two, didn't they?
Yes, for 2, and then the last chance agreement. But
which he chose for, unexplained reasons. You don't have to tell me because it's not in the record, but he chose not to go that path.
That's correct. So what the questions of facts here are is, was he disciplined, or I'm sorry, was he terminated basically for the 2018 Facebook posts. The fact that those posts are protected activity, the defendants recognized they couldn't fire them. I'm assuming that they spoke to their lawyers, and the lawyers he can't be terminated for this, but he was disciplined for his First Amendment protected speech, and I understand that's disputed, but I certainly think that there's question of fact on that. And
I'm going to need to back up just a minute on the time that we have on the due process. And so I wanted to give you an opportunity to address this before the other side comes up. Is the defendant's reliance on the random and unauthorized exception, is that foreclosed by our decision, Bradley?
I'm sorry, what exception did you say?
The defendant's reliance on the random and unauthorized exception, is that foreclosed by our decision in Bradley?
I don't believe it is, Your Honor, because in that case, the facts were different. In this case, they were different in that this individual was a chief, didn't have necessarily any contractual rights. He was an at-will employee. In that case, he did have he had a pre-deprivation hearing with specific notice of the charges. He was able to present his side of the story. In our case,
in the Bradley case, there was no pre-deprivation process.
Correct. There was no pre-deprivation process,
Right.
which in this case, we would submit that there was no pre-deprivation process, and what process there was certainly inadequate and lacking. And I see my time is up. If there's any other questions.
Thank you.
Thank you.
Mr. Actis.
Good morning. May it please the court. Michael Atkiss on behalf of the defendants, appellees. I'm here this morning to request that the court affirm the judgment of the district court granting summary judgment in their favor. Before I had some prepared remarks. I wanted to address some of your questions before I get to those.
Is the grievance and arbitration process still open?
Yes, here's what happened. And the dates mentioned in my brief, I'm sorry, I don't recall them off the top of my head. The union and the city submitted evidence to a panel of arbitrators. I didn't represent the city in that matter.
Does this begin with a formal request for arbitration? I mean, surely you've got to constitute the panel somehow.
The request was made by the union prior to filing suit. It's in the record in this case that I want to say that was back in 2018, 2019,
Okay.
when the union requested the panel. Where the evidentiary gap was at the time of the summary judgment was, well, if that happened, if the union requested the panel, why has there never been an arbitration? And there's no answer in the record.
But the dates you put in your brief, the arbitration is moving forward at this point?
The evidence has been submitted. Closing statements were submitted by the parties, I think on May 5th, which I reviewed. It's my understanding that the matter is under advisement. I don't think that there's going to be any additional briefing. I don't have any idea of what the timeline would be on the panel's decision.
And what is the relief that the panel is being asked to provide the officer in this case?
My understanding is it would be to make him whole financially to the present date. So it would be back pay, I'm not that familiar with the record. Any value of lost benefits, I would assume, and he's asking for reinstatement.
So I would like, if the parties could do this, to have a status report about the arbitration when, maybe within a certain number of days, do you think?
I think, yes. I think that within a certain number of days of the issuance of a decision. Certainly like the parties to file a joint notice with the court within 5 days of receiving any sort of order from the arbitration panel.
Certainly. Was there any other questions on that? No. Okay. Thank you.
What is your view of the record as to what was before the commission with regard to the Facebook posts, as it was considering whether or not it should the termination should go forward?
There's nothing in the record that shows that the commissioners were aware of the posts or the content of the posts. In the notice that the chief presented to the commission, there was a statement in there about, I think, the prior 2-day discipline for a prior incident. But that it didn't describe the speech, didn't describe the
It
post.
doesn't seem to say anything about what this.
The sum and
case
substance of
extension
the
is for.
alleged free speech was not described. There's no evidence in the record that the commission had any knowledge of that. I think counsel mentioned something today that a commissioner admitted that he knew something about the Facebook post. If that's in the record, counsel certainly didn't put it forward in his opposition to summary judgment in the district court. And as we stand here today, I'm not aware of where that might be buried in the record. The commissioners were never deposed.
If you don't mind, can we circle back to the arbitration again?
Yeah, sure, of
And
course.
picking up where I left off in regards to the Bradley case.
Sure.
And so I'm interested to know what pre-deprivation process was provided to Mr. Scheffler.
Sure. And I will. The district court noted it specifically, and although the district court went the other way and ruled the random and unauthorized route.
And I guess that's my question.
Right.
Does Bradley foreclose that argument?
I don't
when
think Bradley
we have here a city that, and so Bradley outlines when it's a city and what due process is required before we go down this random and authorized act. And so what pre-deprivation process was provided to Mr. Scheffler?
I'm going to quote you back the district court, which I agree with was based on the factual submissions that we submitted for the summary judgment, was that plaintiff was read a notice of the charges against him at an April 18th, 2018 interview. This was the investigative interview with Investigator Bartlett to look into the
And
allegations.
so they're required to give notice in a hearing. And so is it the suggestion that qualified as the hearing?
There's more. I wasn't finished. Okay, so he was given the notice of what the charges were at the interview. He was represented by counsel at that interview. He was allowed to give his side of the story.
I'm really
He was-
listening for where there was a hearing.
There was no formal pre-deprivation hearing. There was minimal pre-deprivation due process in the form of plaintiff being given the opportunity at an interview and meetings with the chief to respond to the allegations that were made against him, which he was made aware of when he sat down for the interview with Inspector Bartlett. He presented.
He had counsel and a union rep with him.
I'm sorry?
He had both counsel and a union rep with him. Is that right? You said counsel a minute ago. So.
He was represented by a union attorney and accompanied by a union representative.
Right.
Yes.
Okay. So both.
So it's my position that if pre-deprivation due process is required under Bradley, which I'm not entirely sure that it is in this case, that would be sufficient pre-deprivation process, and that is what we argued on the summary judgment. The district court didn't rule that way. Frankly, there's not much in my brief about it because I didn't observe counsel making that argument before the court. one other thing I wanted to touch on briefly is on this issue of an admission.
Does the
that-
amount of post-deprivation process matter if we're not able to get over the pre-deprivation hurdle
Does the,
after Bradley?
I'm sorry, can you say that one more time?
Yeah. Does the amount of post-deprivation process, talking about where we are as far as the arbitration and those things that are offered by the state, does it matter if the pre-deprivation hurdle is not crossed?
It would certainly limit the scope, I think, of plaintiff's due process claim, and his remedies. I'm not necessarily certain that it would. So I guess what you're asking is, under Bradley, if there's sufficient post-termination, but quote-unquote insufficient pre-termination. Yeah, I think under Bradley then, it would limit the scope of the claim, but maybe not necessarily be dispositive of it. I
Well,
think
there's a lot of law about the interrelationship
there
between
is.
pre and post deprivation, and what your opponents say, where pre-deprivation procedures are both required and practicable, then if you don't give them, you may be in trouble. You may have a due process problem. But the degree of formality and it doesn't necessarily always have to be a full-blown trial proceeding. That's basically a Matthews against Eldridge point.
correct, and there was a case that I cited before the district court. Again, I didn't cite it here because I didn't read plaintiff's brief as making this argument. There was a case I cited. It'll be in the appendix in the record. On that point, Judge Wood, I think it was one of your opinions, but I can't recall the name of it. Concerning the allegation that the defendants have admitted that the speech at issue here was protected by the First Amendment, I'm not sure where this is coming from, this alleged admission. In the brief, plaintiff points to essentially the part of the record where I raised the Mount Healthy affirmative defense to the First Amendment claim. It's clear from the answer to the complaint that the defendants denied that plaintiff's speech was protected under the First Amendment, and notified the plaintiff that was something that he was going to have to carry his burden of proof on in order to survive summary judgment.
This struck me as a very underdeveloped point, actually. There's a lot of law in this area, much of which was not discussed.
On which point?
The matter of public concern issue in the context of a police department. The Supreme Court's been very careful to follow context for this, and I just found it underdeveloped in the briefs, I'll say.
Well, I would say that we submit that the district court's analysis was thorough and correct, that primarily relying on the Clark versus Milwaukee sheriff's case, or Milwaukee versus Clark. That
The district court thought these statements were made for purely personal reasons, but surely they were both, right?
I think there's evidence
Corruption
in
in a police department is a daily issue in some places.
I
would
think
say.
there's evidence in the record that they were made for purely personal reasons, specifically at plaintiff's deposition. When I asked him why he made these statements the way he did, he said frustration. There was no indication that he was intending to air any public issue or foster. You can see from the content, again, when you look at the context of his frustration with the ongoing grievance process he was in for another discipline that's in the record about when he was disciplined for missing a gun that a suspect left in a vehicle.
But that seems like a disputed issue, right? So, I mean, we're here at summary judgment. Summary judgment was granted for the defendants, and so to the extent that we have to view the facts in anyone's favor, it's a it's a plaintiff's favor. And so you're saying that he, the real reason he posted the Facebook post was personal. He and the subject matter of the post seemed to indicate a more kind of broad subtopic matter than just his own personal grievances with the police department. So isn't that a disputed issue?
I don't think, and I think the case law is clear that the topic in general is not dispositive of the issue. So certainly the topic of public corruption or maladministration of a city is certainly a topic of public interest. I think when you combine the personal motive, the ongoing grievance, and it may be disputed who was right or who was wrong in resolving that grievance, but it's undisputed that there was a dispute about it that the plaintiff was displeased with, and that's what was motivating him in his frustration to, call the administration what show, and say corruption ... weird. So I think when you look at that context or that content, along with the context of the grievance and the sorry, I lost my train of thought. The frustration, you're looking at content and form to determine if we have a matter of public concern under Connick. So I think the district court was correct in finding that plaintiff didn't reach that bar in this case. And I think, importantly, plaintiffs waived that argument by not really presenting much, if at all, on that or the issue of Pickering balancing to the district court. Frankly, plaintiff doesn't put much forward for this court on Pickering balancing. I think he only addressed maybe one or two of the factors. Some he conceded went in our favor. Others he didn't address at all. One factor he claims tips in his favor was that, there's no evidence or indication that this inhibited the plaintiff's ability, the speech inhibited the plaintiff's ability to do his job. But, I'm out of time. I'll stop unless you want me to finish my sentence.
You can go ahead and finish your sentence.
I was going to say that at that point that the plaintiff raises there, the courts noted prior in the Lulowski versus Desplaines case that part of a police officer's job is to foster goodwill towards the police department. And in light of the comments that plaintiff lobbed out there on Facebook, I think this clearly interfered with his ability to stand out in the street and represent the city that way.
Thank you, Mr. Atkins.
Thank you.
Mr. Herbert, I'll give you a couple of minutes of rebuttal.
Thank you, Your Honor. What's important to remember here is what we're looking at, and this is the context of a granting of summary judgment. These issues, the intent of the defendants, whether or not they had a discriminatory animus, those are questions for a jury.
Can I nail down one other point? You started out with some official capacity claims, and they're out of the case at this point, right? You're not really contesting that here.
The official capacity?
Right.
Well, we did contest those because Chief Dumas clearly violated a constitutional right of.
But you need, for official capacity, you need to relate this to the city, basically. You need to satisfy Monell standards.
Well, I think what we need to do, Your Honor, is obviously a government employee is entitled to qualified immunity for acts within the scope, but they're not allowed to.
That would be an individual capacity case for qualified immunity. An official capacity case is the same as actually suing the city.
Okay. I don't believe we waived those, Your Honor, but I understand the point that you're making.
All right, go ahead.
this issue about we talked a lot about the due process claims, and obviously that's a big part of it. It resulted in the biggest damage to the plaintiff, but there's also other claims that we clearly show that that my client was discriminated against, retaliated against, and it was based partially on race. There is ample evidence in the record that wasn't reviewed by the district court in this case. It's undisputed that there was 67 additional facts that were not considered by the district court in this case.
He explained why.
He did, and I would acknowledge that that we probably did not do a great job fleshing out the argument. But Your Honor, as Your Honors know, we were responding to a summary judgment, and the burden really was shifted in this case improperly, and with all due respect to the district court. The defendant had the responsibility to prove that there was no genuine issues of material facts. We certainly could have remained silent without answering anything, and we believe that we should have survived summary judgment in this case. But we did present substantial evidence of a racial animus of the decision makers, and there's suspicious timing, certainly, and suspicious facts relating to the termination, and these are issues that only a jury can determine. The defendants say it was lawful. We say it was not lawful. A jury has to make that credibility determination.
All right. Thank you, Mr. Herbert.
Thank you.
All right, we'll take the case under advisement.
May I, Judge, will you issue an order on the request for a stay?
Yes. All right, case number 3 is Curry versus State Auto Property and Casualty Insurance Company. All right, so we will hear from the appellant, Mr. Anspach. Please proceed.
Good morning, Your Honors. May it please the court. Defendant State Auto issued a policy of homeowners insurance to the plaintiff, Shanice Curry, and during the term of that policy, which was from September 15 of 2018 for 1 year, there was a fire. Defendant denied coverage for the fire. The issue in this case is whether the plaintiff resided at the property, which is referred to as the 10th Street property, at the inception date of the policy. That term is set forth in the residence premises definition of the policy, which states that residence premises means the 2, 3, or 4 family dwelling where you reside in at least one of the family units on the inception date of the policy. The defendant asserts that the fire was not covered because plaintiff did not prove residency under the terms of the policy. It's undisputed that that policy, since it was issued in the state of Wisconsin, must be construed under Wisconsin law. And under Erie Railroad versus Tompkins, a federal court sitting in Wisconsin must decide the terms of the policy, including residence and reside, under the law of Wisconsin as determined by its legislature and its enactments, or by the highest court of the state in a decision. The Wisconsin Supreme Court has long held that residence is determined by mere physical presence and intention. In Washura County versus Calumet County, the Wisconsin Supreme Court held that, quote, residence is established by the concurrence of intention and personal presence, and that, quote, continuous personal presence thereafter is not essential to a continuous residence. That holding was affirmed by the Wisconsin Supreme Court in Milwaukee County versus State Department of Public Welfare, where the Supreme Court again held.
There, Mr. Ansbach, those cases, they were construing residence as it appeared in various statutory provisions. Is that correct?
Correct.
How useful are cases that address or define terms in the statutory context when a particular statute has particular purpose, it may have other context? Why do you think we should import those definitions into the insurance context, which is basically a breach of contract case?
That's an excellent question, Your Honor. However, there are no cases decided by the Supreme Court of Wisconsin, or for that matter, an appellate court in Wisconsin construing this provision in this policy. In fact, I don't believe there are any construing residence or reside in an insurance policy.
But there are Wisconsin cases, actually many of them, about the way one interprets insurance policies more generally. Every state has its own law on that. And the district court looked to those cases, giving Folkman against Kwame, for example, you've got to give the language its common ordinary meaning, what the reasonable person in the position of the insured would have understood the words to mean. And if there's an ambiguity, if after you've done that, you're left with an ambiguity, then there's the contra proferentum rule, but you don't get there right away. And so the district court judge says that he needs to give this term residence its common ordinary meaning. That's under Wisconsin law. And he then says a reasonable person would understand, quote, the dwelling where you reside, close quote, to mean the place where the insured actually lives. And he recognizes that it doesn't have to be the sole or primary residence. That's one of your points. The fact that she's got some other apartments isn't dispositive. But he says a reasonable person would nevertheless understand the clause to require her to maintain and use the 10th Street property as a home, even if it was only one residence among many. And then he, with that idea in mind, he looks at the undisputed facts, and he says it doesn't qualify as a home there. You know, most people don't have homes with no running water. Most people don't have homes with, you know, no door in the front, you know, and other, you know, it goes through the whole thing. I'm sure you know it all. But I don't see the legal error in Judge Edelman's approach to the construction of what, as Judge Lee said, is fundamentally a contract. You're trying to figure out what did these two contracting parties decide to do, what was the insurance company, what risk was it undertaking. Obviously a risk for property in which somebody resides is different from a risk where the person is never there, you know, or is not residing. Usually there's a different, you know, schedule of fees for commercial property and so on. So I just don't see where he's wrong to say, let's look at this common sense interpretation. And the common sense interpretation isn't something where property like this, that you're just in 2 or 3 days a month, it would be covered.
Well, who's to say that Judge Edelman's common sense interpretation is different than your common sense or my common sense interpretation?
Well, the Wisconsin courts were the ones who picked that test, who would pick the test, what is the reasonable person, that's an objective test, in the position of the insured, what would this reasonable person have understood? And so you would do what Judge Edelman did. You would look at things that are as comparable as you can. That's the common law.
I beg to differ, Your Honor. You correctly stated the standard, obviously, that the district court was required, once the district court said the term reside was ambiguous, it was required to look at what a reasonable person...
Actually, he doesn't say it's ambiguous. He says it's not defined in the policy. And then he says, I have to give it its common ordinary meaning and interpret it as a reasonable person would. So he doesn't get to ambiguity. He just says it's an undefined term, which is a different point.
Your Honor, page 4 of his decision, the top paragraph, plaintiff argues that, quote, the dwelling where you reside, unquote, is ambiguous.
As to whether it needs sole or primary, and so he resolves that in favor of the insured. He says it's okay for it to be only one residence among many. So he goes with the viewpoint that the insured wants on that one issue.
Okay, and he says the clause is ambiguous.
About as to whether it need be the insured's sole or primary residence. I don't think you can put a period after the word ambiguous without the rest of the sentence.
Well, okay, here's our position, Your Honor. Regardless of whether the term is ambiguous or not, the decision of the district court is correct insofar as he says we need to look at what a reasonable person standing in the shoes of the insured, how he would view what the term reside means. And I would submit, Your Honor, that a reasonable person standing in the shoes of the insured would determine that the term reside means identically what the Wisconsin Supreme Court decided it means in the Washura County and the Milwaukee County cases. And in those cases, the Wisconsin Supreme Court very definitively said all that was required is physical presence plus intention to remain. And
one night and one intention. That's really what you think the Wisconsin courts think?
that's what they said. And the enactments of the state legislature are 100% adoptive of that language. Now, Your Honor points to what I think is kind of what you might think is an absurd result. Only one day. We're only looking at one moment in time. Is that all that's required, that the plaintiff only be there on one day? The answer is yes. And why is that? It's because that is how the defendant drafted the policy.
But Mr. Ansbach, in the Pamperin case, Pamperin versus Milwaukee Mutual Insurance, the Wisconsin Supreme Court seems to draw a distinction between how one would view the term resident as it appears in insurance policy versus how that term might be defined in the statutory context. I think the quote is something like, the word is an elastic term, which may refer to a temporary sojourner as well as one possessing a legal domicile. So I guess I'm still not convinced that we should put so much weight on cases where the Wisconsin courts have interpreted the term resident, residency, what have you, in the statutory context versus, as Judge Woods noted, the insurance contract context. You seem to be relying heavily on cases where the courts are interpreting the term reside or resident in the context of various statutes.
As does the defendant, Your Honor.
That is true, as does the defendant. But since we're able to do our own independent analysis of these issues, it seems to me that of those two categories of cases, that it would be more prudent to look at the cases where Wisconsin courts have actually construed the term in the context of insurance contracts versus various statutes.
Have they construed, Your Honor, though, the term reside in conjunction
but
with...
they've construed terms like resident, right? Or like the provisions in insurance contracts where they say a covered individual would be a family member who resides with the insured policyholder. I mean, they've interpreted the word resident, reside, resident in the context of insurance cases perhaps not in this particular provision, but in related provisions.
Okay, all right, I give that, I give you that, Your Honor. I'm not familiar with the particular case that you quoted, but
There's one, Welter versus Singer, 126 West 2nd, 242. And the definition given is to dwell permanently or continuously, expressing the idea that a person keeps or returns to a particular dwelling place as his fixed, settled, or legal abode. Reside permanently or continuously.
I would say, Your Honor, respectfully, to all of Your Honors, that those cases don't apply. Because while they may have defined the term reside or residence in terms of continuous presence, this policy doesn't require continuous presence. This policy says that where you reside must be determined at a particular moment in time. I didn't draft the language of this policy, but they did. And that's how they drafted it. They have to live by it. Your Honors, the district court is not free to introduce terms that are foreign to the policy.
But counsel, I'm not sure whether the district court did that. I mean, I think the timing of when that determination is made is a question that is distinct from whether or not someone has a continuing, lives at a place on a continuing basis. So for example, you can see why the insurance contract might designate the beginning of the policy versus, say, 60 days after the expiration of the policy as the time to make that determination of whether someone has, if that's the term, a continuing intention or a continuing presence at that facility.
And that's what I'm doing, Your Honor. I'm saying that at that particular point in time, by her expression and her intention to be there and to remain, and by the fact that she was physically present, she resided there at that point in time.
Is there any evidence in the record as of September 15th, 2018, the house was habitable?
That I don't know, and then again, that's a term foreign to the policy, Your Honor.
Thank you, counsel.
Okay, thank you.
All right, we will now hear from the appellee, Mr. Pickover.
Thank you, Your Honors. May it please the court staff, opposing counsel. Your Honors, I think that the court has aptly pointed out the concerns and the issues that we've raised in our brief. I respectfully disagree with counsel in his interpretation of the Washoe County case. In that case, the court is looking at residency prospectively. The court is saying, or looking to establish, that the person was in fact residing at the property. Once it is established that they live at that property and the intention to continue to live at that property, then you can establish residence. What counsel is saying is State Auto is taking one moment in time, and that's when residency is adopted. No. The policy says you must be residing at the property. It must be a residence premises at the time of policy inception. Not one day, but at some point prior to the policy inception, you must show that you were using the property as a residence. There is nothing in the record to establish that. The case that counsel cites, even if one accepts the intent factor, the intent at issue here pertains to what was intended to remain one's already established fixed place of residence. I would also respectfully note
But doesn't Ms. Curry talk about the fact that she intended to be there? This is the only property that she owns. She goes there maybe a couple nights a month, but repeatedly over time, just not isolated. That she has furniture there, albeit in one room. That you know, she might not carry all the functions of a resident there in that house, but that's kind of her intent.
Again, intention is all well and good, but it is not a factor after the fact. What I intend to do tomorrow or the next day or the next day or the next day is irrelevant. What is important is what were my actions and what were my activities at the time that the policy went into effect. And I would point out that Ms. Curry did testify that she was only using the property randomly. In her examination of her oath transcript, I asked her, how often would you stay at the house? I wouldn't say, because I was still getting things together, so it was random. Random times. I don't. How often? Just random. So once in a while you were there? Yes. So there is no showing that she was there on a continual basis, on a regular basis, that she was using it to live, to eat, although she says she brought food in, to sleep, to bathe, to use the facilities to have heat, to have hot water, to have any of the means that one would associate with a residence premises. She doesn't even know if there was a door behind the panel that had to be removed in order to gain entry into her property. So intent in the future is fine, but it was the intent and the showing of evidence prior to the inception of the policy that shows that she was actually using the property as her residence. I mean, I think the key where Judge Edelman really brought it home was she knew that there were people living in the house who didn't belong there. There were squatters living in her house, and she never called the police. She never did anything. That does not show an intent to be residing in this property.
I'm not sure I'd place huge weight on that. I mean, I think what she's saying is that you could have written a policy that had said this policy is a residential, homeowner's policy, and at such times as this is no longer your residence, you have a duty to notify the insurance company, and there might be an adjustment of rates or something of the sort. But it seems to have this focus on just the day of the inception of the policy.
But it's talking about the fact that you must be residing there, not having an intent. It must.
Right. So what if you leave the next day? You were residing there. Let's counterfactual. I know this is not these are not the facts, but suppose she'd been living there for the full month before the policy took effect, and she's still living there in the day the policy. I don't know what she's doing. She's getting takeout food, Uber Eats, whatever she does. And then she goes back to, the daycare residence, or she goes back to one of the modern apartment. And she just pops in now and then to see how things are going, with maybe the hope that eventually it'll be habitable.
That's still not a residence, Your Honor.
Well, but it was the day the policy started. That's her point. If she'd been living there for a whole month before and the policy starts, and she's still living there on that day, and then the next day she leaves.
But we go back to the definition of what is reside. And I would point out that as recently as February of this year, the Wisconsin District Court, the Eastern District Court, interpreting Georgia law, which I will grant you is not the same as Wisconsin, but they do have similar rules of construction, looking at a residence premises case, adopted the definition that we have asserted, which is the policy, the term established meaning, according to Merriam-Webster, reside means to dwell permanently or continuously, occupy a place as one's legal domicile.
Now, so what do you mean by continuous? Suppose she had this place where she stayed during the week, and she has another place where she goes for the weekends, Friday and Saturday night, a nice, place in, Door County or whatever, some additional place.
Well, I agree with you that, as Judge Edelman noted, someone can have more than one residence. But that residence has to be habitable. It has to be a place. It has to be a place where you can sojourn, where you can stay, where you have the means to live, not just lie in a bed and not have a bathroom, not have an oven, a stove, a kitchen, a refrigerator, bath facilities. It has to be a habitable place of abode. And there's nothing in the record to establish that this was a habitable place of abode.
How would you propose that we determine whether or not an abode is habitable? How would you articulate that test?
Well, I think that the issues that were raised by Judge Adelman and as we presented to Judge Adelman, which would be what I've just said, and I don't want to continue to repeat to the court what I've said, but I think the very basic essence of the fact that, let's start
Also, for example, you say that there was no heat. Unfortunately, there are lots of people in Chicago that live without heat in the wintertime. So would you say that all those people don't live where they live?
No. But
right, and so I'm asking you if there is some sort of, to articulate some sort of test or list of factors or what have you, that you would propose that we consider to determine whether or not a particular place is habitable.
I would argue, I would assert, Your Honor, that yes, there are many people who live without heat, and they do so unwillingly or because they cannot afford to. In this particular instance, Ms. Curry didn't even know if she had heat. She didn't know if her furnace was working or her hot water heater was working. So I think some of the factors that have to be taken into consideration in this case is, what did Ms. Curry know about her own property? She didn't know if the hot water tank was working. She didn't know if the furnace was working. She didn't know if the electrical initially was working, but then all of a sudden the lights worked. So, I mean, in many cases where someone is living someplace where they don't have heat, they know they don't have heat, and they have to live with that fact, whether it's because they can't pay their bills or because their heat is off for some reason. But in this particular case, there is no evidence in the record as to what Ms. Curry knew was working and not working. So how can you claim habitability of a property when you can't even identify what in fact was or was not working? And that's why I think the factors that we've attributed in this case go to a point that suggests she was not using it as a residence. Whatever her intention was in the future, she was staying there to make sure probably that the squatters didn't stay there all the time. But she wasn't using it as a place of abode. She didn't have a lock on the door.
So do we look to dictionaries? I mean, I'm trying to think. Judge Pryor suggested some things that courts have looked at. Do you say that the concept of residence has a certain aura of permanency to it, even if not every day, but constant? One would need to come up with a definition. Courts do sometimes look at dictionaries.
Well, in this case, courts should be looking at dictionaries. The construction of the statutes that counsel wants you to look at are completely unrelated. It's the insurance commissioner who is vested with the power to issue policies, to order their revision, to order terms to be added. The insurance code is the code that guides the issuance of insurance policies.
But we also need to follow the methodology that the Wisconsin courts would follow. This is not our playground. It's their law. We need to follow what they do.
Right, and so they say, look at the reasonable the construction that a reasonable person would have. What reasonable person would be looking at statutory definitions? They'd be looking at the dictionary, just as Judge Adelman did, and just as other courts in Wisconsin do. They look at the common, ordinary word of the definition of the word reside, which is what I was pointing out to in this Moutry case, which is 2023 Westlaw 2019342. There, the court again looked at the common definition and said, "This is what it means. It's not ambiguous. It means to dwell permanently or continuously. Where is the permanence or continuous prior to the inception date of the policy?"
Are there cases on the other side of the coin, like discussing whether, a single night at a hotel means reside, or visiting a friend means reside? I mean, I'm trying to think of hypotheticals where you would have non-permanent occupancy of property.
I have to apologize to the court. I am sure that there are, and I believe that one of the cases the plaintiff cites, I don't remember which one, addressed some of those issues, and I think that the courts have ruled that staying in a hotel for 1 or 2 nights or staying at a friend's house 1 or 2 nights is not residence. It's a temporary stay away from your property. If, for example, when I was a young child, my parents moved to another state and we were there in a hotel for 6 weeks, I might argue that was a residence for purposes of our stay because we were there or needed to be there for a permanent period of time. I could see that arguably being a residence, or if one's staying in a hotel from month to month to month, that would be their residence. But being at a hotel for 1 or 2 nights, like I did last night, it's not my residence. I concede that point. Staying at my friend's house, if I were to go to see someone here in Chicago who I knew, that would not be a residence. That's not living in a home, residing at a place of abode for any long period of time. Judge Lee, you look like you had a question. Does the court have any other questions?
Thank you.
Then I thank you for your time.
Mr. Hanpak, I'll give you a minute for rebuttal.
All right. I would assert that looking at a case, 2 cases, Washura County and Milwaukee County, that construe statutes and the meaning of the word residence within those statutes are appropriate here, because this policy, as I said on page 14 of my reply brief, contains a provision which says conformity to statute or rule. Any provision of this policy, including endorsements which modify the policy, which we have here, that is in conflict with the Wisconsin statute or rule is hereby amended to conform to that statute or rule. This company, State Auto, is deemed to have known what the statutes and decisional law of this state was when it drafted this policy. And so when there's decisional law of the state which says physical presence plus intention establishes residency, the policy has to be construed in accordance with those decisions. And one other point I wish to make, Your Honors, and that is there is a decision, Your Honor, which talks about non-permanence resident, and that is the Thorne case, which this court decided. Now, this court said in that case, Thorne's physical presence plus his subjective intent to reside there was all that was required, and it was a situation where he was
That's
there.
the Indiana case, though.
It was, Your Honor, although it doesn't, the decision in this regard doesn't place itself under Indiana law. But yes, arguably it was. But then I think this court has an obligation to look and see, well, what is the difference between Indiana law and Wisconsin law on this matter? And on this matter, there is no difference whatsoever.
Thank you, Mr. Hanpak.
Thank you.
The case will be taken under advisement. At this point, the court will take a brief recess, 5 minutes. The fourth case this morning is Anthony Patrick versus City of Chicago. We will hear from the appellant. Ms. Kwok? Whenever you're ready.
Good morning, Your Honors, and may it please the Court. I represent the appellant, Anthony Patrick. Reversal of the District Court's order dismissing Mr. Patrick's Section 1983 Fourth Amendment claims for unlawful search and seizure and for unlawful pretrial detention, as well as claims deemed derivative of those, is warranted for the following reasons. First, Mr. Patrick's claims asserting unlawful search and seizure of his home and property are not barred by collateral estoppel based on an earlier ruling made by Judge Andrea Wood in a separate proceeding.
So can I pause on this for a minute? Because as I understand from the government's filing, they're conceding error that the search and seizure claims need further attention. And what I'd like to hear from you is, if that's correct, then what else among the derivative claims, whether it's conspiracy or state claim, what else goes along with that, if anything?
Specifically as to the unlawful search and seizure claim, Your Honor?
If the government is correct, I mean, we'll make our own independent determination of all of these things, but if it is correct that probable cause for the arrest isn't the same thing as the ability to go into somebody's house and do the search and seizure, and the further proceeding, however they may come out, further proceedings are necessary. Is it just that count that goes back? Is there anything else that is related enough to that count that it should also receive further attention?
Absolutely, Your Honor. There is a count for conspiracy for failure to intervene, one related to supervisor liability, and an Illinois state claim for indemnification that would all relate back and also should be reversed. The dismissal of those should also be reversed.
Okay, now is the state claim for indemnification necessary? I thought that was just something that the city has a law in place that you don't need the claim. People frequently do raise this claim. There's no doubt about that, but I'm just wondering how necessary it is.
That may be the case, Your Honor. Yeah. If there is a claim for indemnification, then that should also be reversed, though.
Okay.
And as Your Honor said, I was going to note that the defendants do concede in their brief that such claims were improperly dismissed, so I'll move on to my second point, which is Mr. Patrick's Fourth Amendment claims for unlawful pretrial detention were also improperly dismissed because they are not barred under Heck versus Humphreys, and also because this is a de novo review, that they were sufficiently pleaded. Your Honor.
The time that Mr. Patrick spent in pretrial detention, the time that is at issue in your claim, was that time credited towards his sentence eventually?
It was, Your Honor. So there was one count that Mr. Patrick pleaded guilty to for aggravated discharge of a weapon, and as part of that, the time that he had spent, the 5 years that he had spent in pretrial detention, had been credited.
And that was all of it, too. There was nothing left over that he did not receive credit for.
That isn't clear, Your Honor. They did say 5 years, and I'm not sure if it was the exact amount to the date as to what was actually credited. There was the 5 years, but I'm not sure if it was exactly 5 years that he had spent in pretrial detention. The record does not reflect that.
But the problem is, he did plead guilty to this, and those 5 years were allotted to a lawful punishment for the offense to which he pleaded guilty. So it's hard for me to see how he can challenge the 5 years without running into Heck. This conviction has never been set aside. It's never in any way gone through any of the processes that Heck recognizes. So I don't see how he could. I don't see how he can proceed that way without a Heck problem.
Your Honor, it is not a Heck. Heck isn't invoked because Mr. Patrick isn't contesting the validity of his conviction for discharge of a weapon. He's contesting the actions of the police officers that ended in additional 17 charges that were far more egregious than the charge for discharge of a weapon.
But he's never convicted on those charges. That's where I'm having trouble with that fact, and he is challenging de facto, some or all of the sentence he received for the charge that he did plead to. I mean, he may not be happy that these other charges got tacked on, but they all go away too.
In part, Your Honor, there could be an issue with damages in terms of the time that he had spent in pretrial detention.
But it's a lawful. But it's been translated into a lawful sentence, though. Nobody says this sentence exceeds a statutory maximum or in any other way is inappropriate.
I understand Your Honor's point. I do want to state that regardless of that issue, this court doesn't have to determine whether that's the case as to the claim for unlawful pretrial detention that occurred post-arraignment, because Mr. Patrick has also alleged a claim for not being properly given a prompt determination of probable cause.
But what do you do about the document from the Cook County courts that the government has proffered to us showing that he in fact did get a prompt arraignment hearing within the 48 hours?
Your Honor, there are some issues with that document. First, we're here on a 12b6 motion to dismiss standard, and while the court may take judicial notice of certain documents or facts within public records, those facts have to not be up for reasonable dispute under the federal rules of evidence.
What's your dispute? I'm looking at this document.
Your Honor, if you look at the I'm going to the record, Your Honor, to the certified statement of conviction. Mm-hmm. It says that there was a finding of probable cause. So Mr. Patrick was arrested on, I believe, June 15th of 2013, and the certified statement of conviction very clearly states that a finding of probable cause, a determination of probable cause, was not made until June 26th.
But then it also says on the 17th, well, on 6/21, there's a motion that things are happening in branch 48, room 2. And I'm distinguishing between the hearing and the determination. It's not unusual. I don't think Riverside says you have to have a final determination in 48 hours. You have to have your hearing.
Judge, it does state that there was a hearing scheduled on the 17th, but it also states that on the 17th and then again on the...
And special conditions of bail were ordered that day? His demand for a trial that day?
Your Honor, all that goes to the reasonableness, regardless of whether it was a hearing was given in 48 hours. Even though that it is presumptively reasonable if a hearing occurs within 48 hours, Mr. Patrick has alleged that the time that was used between his arrest and the probable cause hearing was used to bolster evidence. Under McLaughlin and Gerstein, the probable cause hearing is supposed to happen as soon as the administrative things are done after the arrest. And Mr. Patrick has properly alleged that that time was not used for the administrative issues that needed to be done post his arrest, but were used to bolster evidence to get additional claims against him.
Counsel, would you like to reserve some time for rebuttal?
Yes, Your Honor.
Thank
Thank
you.
you.
All right, we will now hear from the City of Chicago. Ms. Barnea?
May it please the court. I'd like to focus on Mr. Patrick's unlawful pretrial detention claim. That claim was properly dismissed by the district court for two reasons. First, Mr. Patrick failed to state a claim that his probable cause hearing was untimely. And second, Mr. Patrick's claim that officers engaged in misconduct that led to amended, unwarranted charges against him is barred by Heck. As to the timing of Mr. Patrick's probable cause hearing, I'll speak briefly about the certified statement of conviction that we attached as an appendix to our brief. I'll also note that Mr. Patrick did not file a reply brief that objected in any way to that statement, so any issues about judicial notice, being able to take judicial notice, are waived. But it is a certified statement of conviction, and it indicates as follows. He was arrested on June 15th, 2013. He was charged with 2 weapons offenses, unlawful use of a weapon by a felon and aggravated battery with a firearm, and he received a probable cause hearing on those 2 offenses on June 17th, 2013, which is 2 days after his arrest. Neither Mr. Patrick's complaint nor his brief acknowledges that this hearing occurred, and Mr. Patrick did not allege until today that the timing of that hearing was unreasonable.
Can you tell me, looking at that same docket, the criminal matter case summary, there's 2 continuances requested, one on June 17th and June 21st. There's 2 state motions for continuances.
Yes. I cannot speak to unfortunately, I can't speak to the details of what transpired at that hearing, but the document does show that he had a probable cause hearing on June 17th. What Mr. Patrick alleges in his complaint is that he did not receive a timely probable cause hearing, and that officers used those days to bolster the case against him to, deprive him of a prompt probable cause hearing. But again, Mr. Patrick received his probable cause hearing on June 17th. He has not denied that it occurred within 2 days, and he also does not allege that officers did not have probable cause to arrest and detain him, and he does not allege that officers committed any misconduct related to those first 2 charges that were the subject of that hearing that would have delayed his hearing. His theory is framed in his...
So none of the later charges really impacted that initial determination of bond.
Right, that's our reading of his complaint, and also based on what Mr. Patrick stated in his response to our motion to dismiss below, that he's drawn a firm line. He's saying first officers filed these initial charges, and thereafter he alleges that officers engaged in certain acts of misconduct that led to those amended charges that he says are unwarranted. But he has not raised a probable cause challenge or that there was an unreasonable delay as to those first initial charges. So he does not link the officer's alleged misconduct to the timing of the June 17th probable cause hearing. So for that reason, we don't believe that he stated a plausible claim that his probable cause hearing was unreasonably delayed. I'll turn now to Mr. Patrick's claim that the officer's alleged misconduct led to those amended charges. We believe that's barred by Heck because the allegations in the complaint are inconsistent with the offense to which he pled guilty, which was aggravated discharge of a firearm. Under Heck, Mr. Patrick cannot take any position in this case that implies that his conviction or sentence is invalid. But Mr. Patrick's allegations call his conviction into question because if they're true, then he's not guilty of aggravated discharge of a firearm because he acted in self-defense. So some of the things that Mr. Patrick alleges is he lists the evidence that supported a self-defense theory that officers allegedly ignored, including bullet casings and holes that could not have come from Mr. Patrick, evidence that someone named Armand Freeman instigated the incident and shot at Mr. Patrick, and he also asserts that officers withheld exculpatory evidence. If all that is true, then Mr. Patrick did not commit the offense that he was convicted of. So for that reason, we believe the district court properly found that his claim is barred by Heck. Unless the court has questions, I'll rest on our brief.
Thank you.
Sure. Thank you.
Ms. Clark, I'll give you a minute for rebuttal.
Thank you, Your Honors. I'd like to make 2 points on rebuttal. The allegations in Mr. Patrick's complaint allege actions of the police officers from the time that he was arrested, not that they only occurred post-arraignment, that they started occurring from the time that they came into his home without unlawfully without a warrant, and that those actions continued between the time he was arrested to the time of the arraignment, and also post-arraignment when there were misstatements made by police officers at certain hearings. So the actions of the police officers were ongoing, not that they started post-arraignment. The second point I'd like to touch on is the self-defense argument that the defendants are making. If you look at the case that's relied on by the appellees, the People versus O'Neill, it does state that self-defense is a proper affirmative defense to the crime of aggravated discharge of a firearm, but the case goes on to state the court found that jury instructions were proper that instructed if defendant committed the offense of aggravated discharge of a firearm, he could not rely on self-defense, and that was a proper jury instruction. The court also pointed out that the state had to prove 3 propositions, one of which was that the defendant was not justified in using the force which he used. So just because there might have been assertions that there was self-defense does not mean that there cannot be a proper conviction for aggravated discharge of a weapon.
Thank you.
Thank you, Your Honors.
The case will be taken under advisement. Thank you, counsel. Our next case is Mario Arc. I think that's how you pronounce it. I'm not sure. RC? Okay. Mario RC versus Wexford Health Sources. All right, we'll hear first from counsel for the appellant, Mr. Dara? Dara. You may proceed.
May it please the court, counsel? So just mentioned, my name is Matt Darrow. It's an honor and a privilege for me to represent the appellant Mario Arce. I was appointed by the District Court for the Southern District of Illinois to represent him in this case where he pled constitutional violations under 42 U.S.C. 1983, specifically a deliberate indifference to his medical needs while he's an inmate at Pinckneyville Correctional Center. We're here today appealing a summary judgment in favor of Dr. Butelid, Nurse Bloom, and Wexford Health Sources. The law is not unsettled in this area. It appears we largely agree with the district court as well. The issue is the facts relating to Mario's care after a June 18, 2017 incident playing soccer in the rec yard where he was kneed in the thigh.
Can I ask you this, Mr. Darrow? He seems very focused on this compartment syndrome possibility, and yet I am at a loss to find actually affirmative evidence in this record that would allow a reasonable jury to conclude that this is what he had. There's a different way of looking at this record, which is that even though he as a layperson keeps going to the doctor and complaining of maybe compartment syndrome, whatever, but he is pretty clearly complaining over a long period of time of substantial pain. And the prison medical people never get to the bottom of whatever that is. And so I'm wondering, to what extent is your claim here just about the unredressed pain, and to what extent is it about follow-up for compartment syndrome, or a tighter focus on that?
It's a good question, Your Honor, and the claims are for both. He did plead that there were issues with a lack of attention to the pain that he continually suffered over an extended period of time without improvement. That is part of the issues that are on appeal and that were addressed in the summary judgment motion, and the judge should not have denied summary judgment on that. You're correct. Mario is very focused on the compartment syndrome. That's what he understood when he saw a specialist, an orthopedist at SLU Hospital.
But the only thing the specialist says is, I'm going to test for this, come back in a couple of days. That, of course, doesn't happen, but
Right.
it's my lay understanding of compartment syndrome that if that's really what had been going on, it would have shown up in all of these subsequent examinations, even by the prison doctors. So I don't see where the 2 or 3 days, or at least I don't see evidence in the record showing that this 2 or 3 days somehow made a proper diagnosis impossible.
I think there's evidence in the record, Your Honor, and the parties agreed that compartment syndrome can be evidenced by continued progression of swelling, changes in sensation, numbness in the top of the foot, and significant pain.
But they
And
weren't finding that. What they do find is the blood clot, which is serious enough as it is. People die of these things occasionally if they break loose. So,
Yeah.
and they
Which-
treat that.
Well, that was also identified as a fact that a blood clot can result from compartment syndrome. As far as finding it, what the doctors found and what they didn't find and what they wrote down isn't always consistent with what Mario Arce's deposition testimony was, an affidavit that he filed earlier in this case and that we submitted in opposition to the summary judgment, which was that he did have continued pain. He had increased swelling after he returned from the hospital.
The pain is what he's very consistent about.
Yes.
And that, of course, that we actually have cases about people who say, if I'm in pain and you keep trying things and it's not working, then you're not doing enough.
That is exactly true. And I agree with you there, Your Honor, that I think with respect to the pain and the lack thereof with the medications and the continued treatment without any improvement, that alone should have defeated summary judgment on this and should survive.
But does the continued treatment not address the question of regarding deliberate indifference? That the doctors, the treatment plans that they were putting in place were attempting to find the source of the pain?
No, Your Honor, there's no indication of that. There was a situation where there was no pain medication. Eventually, after he was released from the infirmary, he was given Motrin. He wasn't seen by either the nurse practitioner, Bloom, or Butilid for an extended period of time after he returned. Eventually, Bloom saw him after 10 days. Butilid much later than that. And at one point, they gave him a stronger narcotic for just 1 week called Ultram that helped. Butilid testified that he prescribes it for a week because he wants to check you at the end to make sure you still need it and that it's working. He never came back and checked him, so that expired. So it was 1 week of relief. It did work. Ultimately, he had a situation with where he had neuropathic pain that was identified, but the physical therapist was telling them both that he needs something for this neuropathic pain back in the fall of 2017. He didn't get that until the spring of 2018. It was just 3 days. As far as the course of treatment, they weren't really doing anything to identify the issue other than when they were reacting when there were issues, when he'd either have to go to the emergency room or he developed a situation with a blood clot where that was identified. They did give him thinners, I think, for the blood clot purposes. But as far as improving his leg, his mobility, there was a prescription for the physical therapist. That may have made sense at one juncture, but the physical therapist was telling them repeatedly that there was no improvement and something different needed to be done, and they just ignored it.
I think that pain medication is Neurontin? Is that
Neurontin, yes.
Right? And it seems like, at least, that there were prescriptions and orders for Neurontin, as you say, in early 2018, going through mid-20 to mid-2018. And I guess I'm trying to assess kind of the record. putting aside and it is relevant that, of course, that Mr. Arce complained about the pain. Is there anything in the record that would indicate that this course of treatment was somehow beyond the pale or not professionally recognized, or that some other type of medication would have helped relieve the pain when Neurontin failed?
Neurontin worked, but he only got it for 3 days, and starting in March 18, 2018. That was apparently because of a Wexford policy. It was outside of the formulary, so they stopped using it. Earlier, Ultram was the other one I identified. That was a narcotic, a pain medication that worked, but he only got it for a week, and that was in July of 2017. The Neurontin, I think, is a neuropathic or a nerve pain medication, and that's an issue he started having and kept having, but he didn't get it till March 18, 2018.
But no one ever links neuropathic pain to compartment syndrome. And even if we step back and say, well, he starts having pain anyway, he also gets the nortriptyline, which is another neuropathic. And I think that the duloxetine is also neuropathic. Lots of these others are just painkillers, the Ultram, Tramadol, Tylenol, ibuprofen, and so on.
The others were the ones they weren't effective,
basically.
and he continued to complain that they weren't effective. And
They give him a low bunk permit, right? They give him...
I think originally they did after he was released from the infirmary.
Okay.
Yeah. If I can reserve him in my time, I'm glad to answer other questions. But
I'll give you a minute in rebuttal.
thank you.
All right. We will now hear from the appellees. Is it Cree?
Cray, Your Honor.
Cray. Mr. Cray.
May it please the court, counsel. My name is Patrick Cray, representing Dr. Alberto Boudalid, NP Bob Blum, and Wexford Health Sources. The district court's order granting summary judgment in favor of these defendants should be affirmed.
So, Mr. Cray, why doesn't this case, in your mind, fit within the types of cases that Judge Wood was referring to, where an inmate complains about severe pain and basically is given the same treatment over months, sometimes years, with the inference that's completely ineffective?
If Your Honors will entertain me to go a little bit through the factual record here to address that, I think that those facts are what differentiates this case from a lot of those cases. I'm kind of skipping over the compartment syndrome testing and the eventual diagnosis of DVT. Seems like the interest is more on the pain. So starting from there, at the first reassessment on June 28th, after he is seen for the first time after observation in the infirmary, Blum notes no signs and symptoms of distress, and he notes that the bruising is healing. And at this time, the RC is put on Motrin. And though Blum noted some pain at this reassessment, the pain is when he's performing the test for the HOMON sign, which actually diagnoses that DVT. At this time, and in between the infirmary visit and this reassessment, RC does not make any complaints of pain or go to the healthcare unit to seek out pain medication. While Blum, after the fact, may have preferred narcotics or nerve pain medication or muscle relaxers at that time, he does not raise those issues in the moment. And in any event, the Eighth Amendment does not guarantee complete relief from pain or a choice of what pain relief is given. On July 7th is the next visit after the DVT is diagnosed. At this visit, Blum also notes that RC again shows no signs and symptoms of distress. He did not seek out any care from the healthcare unit in between June 28th and July 7th, and Dr. Boudalid testified during his deposition that such reports of pain and such visits to the healthcare unit informs the healthcare treaters whether or not their treatment plan is working and whether or not it needs any adjustment. When he's diagnosed with DVT and he's put on the anticoagulation on July 7th, he's kept in the infirmary for a 5-day period. During that time, he doesn't complain about the pain medication he's receiving, which at the time is Motrin, and he's discharged on July 12th. His next scheduled healthcare visit after discharge from the infirmary is on July 14th, which he voluntarily skips out on, and he testified at the time he was able to ambulate fine on crutches. His next visit is on July 20th, where he sees Dr. Boudalid again in the healthcare unit. And this is the first time that Arce himself articulates to Dr. Boudalid that he is experiencing a worsening pain. And accordingly, Dr. Boudalid responds by elevating Arce's medications by ordering a narcotic, in this case, tramadol. Arce does not complain to Dr. Boudalid or Blum of any pain in between that visit on July 20th and October 27th, over 3 months later. At this visit, he complains to NP Blum about the pain, and at this time...
are those prescriptions carried forward? I understood Mr. Dow to be saying that some of them were just a couple of days and then abandoned.
I did not note in the record where those citations come from, that the prescriptions were not filled. In any event, there's no indication in the record that Blum or Boudalid themselves were made aware of those prescriptions not being filled. And in addition to that, because Arce is not coming to healthcare unit complaining about pain, as far as Dr. Boudalid and NP Blum go, they have no subjective knowledge, which is the standard under deliberate indifference, that this inmate is suffering from pain that's not being adequately treated. And then after Blum is made aware of that next visit on October 27th about increased pain, that's when he prescribes...
In the timeline, though, do we recognize the August 4th grievance?
On August 4th. That was a collegial review, correct?
It's the grievance for the persistent pain.
For the grievance of the pain, as far as I'm aware, is not imputed knowledge to Dr. Boudalid or NP Blum that they are made aware of Arce is still in pain. And this is Dr. Boudalid's deposition testimony, if Arce goes to the healthcare unit and seeks out pain, they're either made aware of that treatment not being given, or they, as they do in several instances in the record here, actually elevate the level of pain medication given because they actually see him. And then after that August 4th is that October 27th visit, which I described, where nortriptyline is prescribed. And then after that, on November 27th, that's 1 month later, Arce goes to Pinckneyville Hospital for an ER visit due to a concern of a blood clot, and he then returns to Pinckneyville Correctional after. Now, the discharge instructions from Pinckneyville Hospital only recommended ibuprofen and an anti-inflammatory naproxen. Blum, on November 27th, again goes above and beyond the discharge instructions by increasing the amount of nortriptyline, which was already prescribed to Arce. Now, there's a span from that November 27th, 2017 date through March 11th, 2018, where he again does not voice a concern, and there's no record evidence of a concern being voiced to Dr. Boudalid or Blum about persistent pain. But on March 11, 2018, Arce sees Dr. Boudalid, where he first complains that the nortriptyline that he's been receiving is not helping. He's not saying he didn't receive it, that the prescription is not given to him, that it's not helping him. And at this visit, Dr. Boudalid changed the prescription to the Neurontin, which Your Honor referenced previously. 5 days later, on March 16th, Arce complains to Blum of continued pain, and at this visit, Blum prescribes the narcotic tramadol. A couple weeks later, on April 5th, and this is the last date I'll give you. A couple weeks later, he complains to Dr. Boudalid about persistent pain. At this time, there's an ultrasound which diagnoses the post-thrombotic syndrome, the buildup of the long-term deep vein thrombosis, and Dr. Boudalid prescribes tramadol, or continues the tramadol prescription to treat the post-thrombotic syndrome.
So even your account suggests a pretty consistent story of pain, actually.
Consistent story of pain. I think that goes hand in hand with the underlying condition that Arce had here, which is a deep vein thrombosis. And the medical evidence in the record shows that this is a condition that has wavering levels of pain, numbness, swollen parts of the body. And I think that highlights the need for Arce to have, in this case, verifying medical evidence which shows that his pain was caused by the inconsistent and unwavering symptoms of the deep vein thrombosis, and not any delay in care or any lack of care. And on that issue, I want to use my remaining time to discuss what Arce argued in his reply brief regarding his need for verifying medical evidence, specifically his need for expert medical testimony. And he argues that the medical record evidence in his deposition testimony in this case alone is enough to satisfy that standard. And he cites, in support of that contention, cases like Williams versus Leifer, Berry versus Peterman, and Grieveson versus Anderson. And those are cases where inmate plaintiffs are withheld from receiving any treatment, and there's medical record evidence showing that once they are given the treatment that they have been requesting, their symptoms immediately subside. And this court has noted in those cases that once that a jury is permitted to find that once that treatment or medication is given to the patient, there's no need for further verifying medical evidence to show. But this is a factually distinct case because the deep vein thrombosis, the inconsistent reports of pain, the varying levels of pain in response to the medications being given, there needs to be some expert testimony or some other form of verifying medical evidence beyond just the medical records to permit a jury to find that there's some conduct from Dr. Butelid or MP Blum that is the cause of the pain or exacerbation of symptoms and not the deep vein thrombosis itself.
We might need to spend some time talking through the Monell claim.
Sure, of course. So on the Monell claim, the three prongs of the claim that we argue that RC doesn't meet any of them. The first being underlying constitutional deprivation for all the reasons explained, that there's no constitutional deprivation as a result of the conduct of Blum or Dr. Butelid. We find that he has not made that showing. As it relates to the three different kinds of actions linking the deprivation to a corporate conduct of Wexford, there's no express policy that is shown to be a cause of the injury. He argues that a attempt to cut costs is the reason why he didn't receive treatment he desired. But the Eighth Amendment doesn't permit an inmate to choose the treatment he wants. And through the timeline of medical care that I described, the complaints of pain as well as other symptoms and the physical therapy visits, those are all parts of the medical provider's decision-making process, and it wasn't a cost-cutting measure that decided why the certain treatment decisions were made. Regarding a widespread practice, he provides absolutely zero evidence of any other inmates and how Wexford's policies were responsible for any injuries that they would have suffered. They're only exclusive to his claims here, which is not sufficient under Monell. As far as a final policy-making authority, this case is similar to the Whitting case, which I mentioned in my brief, which eventually states that Dr. Butelid is a decision maker in the sense that he is on the collegial review, but that does not provide evidence that he's a final policy maker. So that is not satisfied as well. And on the final prong of showing that there's no Wexford moving force, for similar reasons, there's no evidence that Wexford's cost-saving policies or any other policy or practice was the cause of the exacerbation of any of the symptoms. Thank you.
Thank you. We'll give a minute for rebuttal.
Thank you, Your Honor. Counsel provided a detailed history popping through a lot of the notes in sort of a timeline fashion. And part of my problem with why we're here today is, and you mentioned during the police case, the summary judgment standard that's involved. Mario was supposed to, the evidence was supposed to be construed in his favor with all reasonable inferences in his favor. Here, if you look through the briefs, they're very different stories that comes out and emanates when you read through the appellate briefs, if you read through the summary judgment papers, and that's because there are disputed issues of fact here. And those should have been dispositive such that, not that the court would grant summary judgment, but would reject that motion for summary judgment. For example, I think he mentioned several times where Bloom notes in the medical records he's improving or he's better, whereas RC testified that he was telling them he was in extreme pain, he was not better, that it had swelled from his groin to his ankle or to his calves, and that it was worsening. So there are disputed facts here. You can't just cherry pick the ones out that are favorable to their cause. They should have been determinative of this case, and that's why we asked to reverse and remand.
Thank you. And Ms. Darrow, I wanted to thank you for your service to the Southern District of Illinois as well as this court.
Thank you.
We'll take the case under advisement. Thank you. Our next and final case for today is United States versus Brian Statford. We'll hear first from the appellant. Mr. Theis.
May it please the court. Bill Theis on behalf of Mr. Stafford. I'm going to start with the evidentiary issue, although I hope to get to the trafficking enhancement under the guidelines, especially if the court has any questions about that. In this case, the district court admitted evidence that should have been excluded under Rule 404 and Rule 403. The district court did exactly what this court in Gomez said a district court should not do. It said it's going to admit the evidence. It stated 4 bases that he thought hit the mark under 404, but gave no explanation of how its ruling tied in with those categories. And there's really no denying that. The court's order is clear. It's in the appendix. The government doesn't deny that. The government's main defense of all of this is its reliance on this court's decision, United States versus Maybe. And Maybe is a case where the government seems to suggest that the district court doesn't have to explain itself if it relies on the analysis presented by the government. That's cutting it pretty fine with Gomez, and maybe never claimed to overrule Gomez. But invoking Maybe doesn't really work at all in this case, because the government presented 3 bases for admitting this evidence: knowledge, intent, and control of the fort. And in response to that, the court invoked knowledge, intent, preparation, and plan, and said nothing about control. And as I noted earlier, it never explained how its analysis lined these up under Gomez. So I don't think you can fairly say that this is a Maybe case.
Well,
where the court,
certainly the court doesn't say very much. I agree with that. But it does cite non-propensity uses for the evidence, which is one of the big points of Gomez. You need to be able to show all the way down the line a chain of non-propensity uses. The court's very careful with its limiting instructions, where I think it elaborates a little more for the jury, both at the time of admission and then at the end of the trial, that this evidence cannot be used just to assume that something he does on November 1st is the same as something he'll do on November 2nd. So I actually think this evidence is right on the margins anyway. It's just a day before. I mean, it's so interlinked with what happened on the next day, on the November 2 side of things. I'm willing to look at it under the 404B rubric, because that's what everybody's doing. There are issues after Gomez about how much of the 403 side of things need to be done just sua sponte by the district court, and how much does the defense have to be saying we need more balancing, we need a more fulsome explanation. I mean, I just, in the end, I can't see a substantive problem here. It seems like within the discretion of the judge to say intent, preparation. I mean, there's a lot of preparation that you can see out of that November 1's course of events.
well, the judge can certainly look at those things, and I think we all agree the judge has a lot of discretion. But I think this court has also been clear that you folks can review that discretion only if the judge explains what he or she is doing, and that explanation was not there. And it's true, as you pointed out, the judge makes a fleeting reference to propensity and acknowledges we can't
in the
use
instructions, yeah, he
well,
warns the jury off.
We'll get to both of those. In terms
Okay.
of the order, he really doesn't say anything about propensity. And one of the problems is the government, although it says, oh, we don't want to rely on propensity, they don't say a word in their pleadings about how they satisfy that burden. They say, we need to admit it because it shows intent. Well, of course it does. But does it show intent without showing propensity? And coming back to the instructions.
And what about plan and preparation? I mean, getting the same stuff? I mean, the same gun, the same serial number?
You know, if you were sitting as the trial court, Your Honor, I could see how you would explain that, but the judge didn't explain it, and the government didn't explain it. That's one of the weird things about the government's invocation of maybe is that they gave the judge a deficient explanation, which in their minds covered intent, knowledge, and control, and said nothing about preparation and plan. And the judge says nothing about control and invokes preparation and plan, even though neither side had presented him with any argument on that.
Mr. Tice, was there a hearing on the motion in limine? We were struggling to find a transcript, because typically on something like this, one would expect a hearing where there would be some back and forth and the judge could provide some more of his or her insight.
There was not, and my apologies for not explaining what I maybe foolishly assumed was obvious. There was not a hearing. There were these pleadings, and then we get the order from the judge before the trial.
So there wasn't a hearing where the judge kind of had
no, absolutely not. No, that did not happen. And I want to loop back for a second to the whole idea of instructions. That area also has its own problems because the judge gives two different instructions. During the trial, he says you may only use this for knowledge and intent. And then at the end, he tells the jury, oh, you may only use this for intent and control. Now, I know we make this assumption that jurors follow instructions, and of course, as a good defense lawyer, I think that's all wrong. But I live under that assumption. But when we get to the case where the judge is giving differing instructions, and I'm sure the government has some theory as to why these two instructions can be lined up and make perfect sense. But wait a second, we're talking about a jury that's honestly following the instructions. What is the jury to think about this? If they're really paying attention to these instructions, I don't know how they can process that. Now, we've talked a lot about 404, and I don't want to lose sight of 403 because it's basically that two-step process. And really, in 403, once again, the judge says nothing about how he analyzes 403. The government doesn't deal with it. And this was another strange aspect of this case is the government came down so hard on control. We got to show Stafford's control of the car. And how did they want to show it? Because he sold some drugs in the house. That is something that the judge should have been thinking about if the judge was going to be making a principled exercise of discretion. And we can parse that out now and try to imagine what a good district judge would have thought, but the good district judge in this case did not tell us what he actually thought. So
could you say just a word to, I understand your basic argument on harmless error is just the fact that there were the two trials and a different result. Is that right?
Well, yes, with this sort of nuance. I'm not urging this court to adopt a rule that says if there's a mistrial the first time and then there's different evidence the second time, that means that the error was harmful. But I'm saying you can draw inferences about the harmlessness of the error, about what happened. And the government wants to take you in a totally wrong direction by citing Powell, which is a double jeopardy case. It has nothing to do with this. So I hope I've answered your question on that.
Yeah, that's fine.
I guess I still have, I said if I had time, does the court have any questions about the traffic enhancement, or I could address that later in rebuttal? Or
why don't, if you would like a minute for rebuttal, you can do it then.
Oh, okay.
I don't see any particular questions at this time.
All right.
Thank you, Mr. Tice. We'll now hear from the government. Mr. Green.
May it please the court, David Green for the United States. The district court did not abuse its discretion by admitting the November 1st evidence under 404B and Rule 403. That evidence included the drug transaction as well as gun possession. that evidence was properly admitted for the non-propensity purposes of showing first the defendant's control and access of the Ford Taurus, where items relevant to the charged offenses were found on November 2nd, as well as the defendant's intent to distribute the drugs found in the Ford Taurus on November 2nd.
But the judge has to do more than that, right? There's to be more than just identifying what the eventual non-propensity purpose is. Doesn't, under Gomez, the judge has to provide the non-propensity line of reasoning from beginning to that end purpose. Is that correct?
Your Honor, what happened in the district court did comply with Gomez, which required that the proponent provide the non-propensity purpose. Here, this was fully briefed by the parties. The government proffered those non-propensity purposes. Government agrees with defense counsel that there wasn't a hearing, but then there was the written order after full briefing at which the court identified the non-propensity purposes in its written order, as Gomez encourages.
So you're standing on the language in your motion for the explanation of what the non-propensity purpose the government was suggesting?
Your Honor, that is certainly relevant, and the government believes that the court should review the entire record and not just look narrowly at the written order. It was clear that the district court considered this issue carefully, and there are all different points throughout the record where that was indicated, where the court was carefully considering how to word the limiting instruction, again, consistent with
I guess, I'm not sure where in the record you can point to that says, other than the order, that the district court considered the motion at that point carefully, because all we have is the order, right?
Correct, Your Honor. There wasn't a separate hearing, but that order did identify the non-propensity purposes, as well as reference the 403 analysis, and that goes beyond.
Well, but the reference is just that. It's a fleeting reference to 403 analysis. Presumably, one would think that particularly here, where on the one hand, you would look at the probative value of the fact that of the temporal proximity, right? But you also have to weigh the prejudicial value of the temporal proximity and the sale of the narcotics, which is one of the counts that the jury had to consider. And so one would expect some sort of explanation, kind of balancing that out so that we can review how the court exercised discretion in weighing all of those factors. But at present, all we have is this 12-line order.
Your Honor, the district court certainly could have said more at that time. However, the court's...
Looking at the order, just to help us, where does he give an explanation?
Well, Your Honor, the government's position is that the court did rely on the full briefing of the parties. The order does list and describe the non-propensity purposes, but the order could have said more. However, later in the trial, the court did specifically reference the potential risks associated with 404B evidence and explained that that was why he was carefully crafting the limiting instructions that were given not once but twice. The form of the limiting instructions was agreed to by all parties, as well as the timing, which is another thing that Gomez encouraged district courts to do, was to consult with the parties. So it was given before the case agent's testimony introducing the November 1st evidence, as well as in the final jury instructions.
Could you address a bit the issue of assuming for purpose of argument that this case is remanded, what the scope of the remand should be?
Your Honor, the government does not believe that the case should be remanded, of course, and government asked the court to uphold the jury verdict. I haven't addressed the sentencing issue yet. That could be a separate remand potentially, but the government believes that this court should uphold both the jury verdict as well as the sentence that the defendant received.
No, I understand that's the government's position. I'm just saying that if the court were to hold that the explanation does not meet the standard in Gomez and its progeny, does the government have a position as to what the scope of an appropriate remand would be in this case?
Your Honor, I apologize. I hadn't prepared specifically for that question. Perhaps a remand could encompass an opportunity for the court to further elaborate what its reasoning
Well, I guess that's what I was getting at, is that, we could remand for a new trial. There have been instances where we remanded for just a further explanation of what the judge did, and I was wondering whether the government has a position one way or the other on that particular issue.
Your Honor, if this court did find that the record was lacking, the government would believe that it would be appropriate for an opportunity for further explanation or elaboration on the district court's order admitting the evidence. Your Honor, if I may briefly, even if the court were to disagree or believe that the record is insufficient, any such error was harmless. The fact that the prior jury hung on the November 1st charges is of no moment in this scenario. The parties don't know why that first jury hung, and the court here should not speculate. And this is not a controlled experiment. There were important differences in the evidence that was offered in the second trial, and in particular, the defendant on appeal and below doesn't dispute that the evidence from November 1st regarding the gun, which was found in the vehicle on November 2nd, was properly admitted. That was not heard at the first trial. And so there's important differences in the presentation of evidence. But even putting that aside, the evidence here was extremely strong. There was October 24th evidence of another gun transaction that showed the defendant accessing the Ford Taurus. There was the gun in the house on November 1st, discovered in the car on November 2nd, that had the defendant's DNA on it. There's a second gun discovered in the car on November 2nd, where a matching box with the same serial number was found in defendant's garage.
Didn't the jury in the first trial have all that evidence as well?
The jury did hear much of this evidence, but again, they did not hear the evidence relating to the gun on November 1st. And another important piece of evidence is at the tail end of the November 1st evidence, there's a conversation between the defendant and the source in which the two are discussing and contemplating a future drug transaction. And the defendant is discussing accurately, according to the government's drug trafficking expert, what the prices of cocaine were. And this is relevant because it goes to the intent to distribute the drugs, including cocaine, that were found on November 2nd. So there's no transaction involving cocaine on November 1st. And the jury heard this discussion between the two, the source and the defendant, in which they go into significant detail about the price of 1/8 of a kilo, which they refer to as 4 and a split, as well as the prices, market rates of a kilo of cocaine.
So can I ask you a quick question about the trafficking part?
Yes, Your Honor.
Mr. Tice argues that however well the CS and Stafford may have known each other, we're asking for a pretty big inference to know that the type of prior conviction was known to Mr. Stafford. In other words, prior conviction for a crime of violence, a controlled substance offense, or a misdemeanor crime of domestic violence. So I'm perfectly willing to think if they were longtime friends, maybe they knew that they each had a record, but you're asking for a lot of granularity there. What confidence can we have that this was really satisfied?
Your Honor, it was really exceptional facts in this case, where it was the defendant's own representations that they were decades-long best friends, that he had.
Yeah, I accept that, but I don't know what you tell your best friends. My priors are, all, whatever, controlled substance offenses.
Your Honor, it isn't in the record, the specific conversations, but we believe that the district court did not clearly err by a preponderance of the evidence in making that inference, that given how close they were,
But that's its only reason, right? That they're just very close, longtime friends. So he's assuming a lot of personal knowledge about
that was
the
the
person.
Basis for the decision that the district court explained at the sentencing hearing. But again, the defendant didn't contest that at sentencing or in the filings that the defendant did in fact have qualifying convictions.
No, but it's the knowledge. I mean, the fact of the convictions is quite different from the knowledge.
Correct, Your Honor. And again, we just argue that this district court did not clearly err by a preponderance of the evidence on the record before it. And I see my time is up, so unless there are any other questions, I'd ask the court to affirm both the verdict and the sentence.
Thank you. Mr. Tice, a short rebuttal.
I want to start off by answering the question that Judge Lee asked about what would be the scope of a remand if there were one. As I understand it, what normally happens when there is an evidentiary error that is found to be substantial, the remedy is a new trial. I don't know that there are cases that remand solely for the purpose of the district court judge making the record that he or she should have made. I can't say that's out of the question because I haven't researched that, but it's certainly our position that the proper remedy would be a new trial. The government has also made much about the district court's crafting of limiting instructions, but I don't think we can lose sight of the fact that the purpose of a limiting instruction as opposed to a corrective instruction is to tell the jury, look, you're going to hear some evidence, but I want you to consider it for a limited purpose. That presupposes that the evidence is properly admitted. So if we're going to focus on the limiting instructions, we better make sure that we haven't hopped over the predicate question, was the evidence properly admitted? And here it has not. I see I'm out of time. Thank you very much for your attention.
Thank you, Mr. Tice. Mr. Tice, we thank you for your service to the court.
Thank you.
All right, that concludes our arguments for today. We will adjourn and we're in recess. Thank you.